right, well, it is 5:30, February the 11th, 2016. Before I call this to order, I'm going to ask our attorney advisor, we had been continuing the prior meetings so that
Recessing, yeah.
we were recessing. So we cannot open a new meeting. We are coming back out of
That is
recess.
correct.
Okay. I just want to make sure, so. Very good. At this time, I will call the meeting back into order. It's been 2 weeks. We had a lot of reading to do in the past 2 weeks. So at this time, does any board member have a question as to the evidence that was submitted and we were to review? Mr. Payne?
Not at this time.
Anybody? Okay. Mr. Plumley, is there anything you needed to add to this?
Not at this time. I have two additional witnesses to be very brief. I'd like to put them on before resuming with Mr. Brown, who will take a little bit longer. These are very short witnesses that I hope not to take too much of the board's time with, but to get right down to it, if I could get them started.
Sure.
Okay, that'd be fine.
Tom Morgan is the first. You need to be sworn in.
Here, sir.
Thank you.
Mr. Morgan, please state your name.
My name's Thomas Morgan.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. And where do you reside, Mr. Morgan?
Norfolk, Virginia.
Okay.
Mr. Morgan, I'm going to hand you what is a resume or CV with your experience and background, and I'm going to pass a copy of it to the board members and the clerk of the board. I do. It's well. Shoot, I'm sorry. I started the wrong direction. Mr. Morgan, you stated that you live in Norfolk, Virginia. What is your profession?
I'm primarily a sound engineer.
All right.
What?
A sound engineer.
Okay.
And where's your place of employment?
I currently have a residency at a club called Work Release in Norfolk, Virginia.
And are you also employed by Audio Light and Music?
Yes, sir.
All right. And as part of your work, do you install sound systems at various nightclubs and bars?
Yes, sir.
All right. And how long have you been doing this work?
Since about 2006.
And how many bars and nightclubs have you installed a sound system in, approximately?
I've done quite a few. I would say probably close to 100.
Okay. And in that time, have you had cause to measure sound levels to test for noise in the vicinity of the club?
Yes, sir.
Is that common work that you perform during installation and post-installation?
Fairly common.
All right. I would move to enter this gentleman, Mr. Morgan, as an expert in the field of sound measurement, noise measurement, to provide a brief testimony on work that he performed very recently over at Headlights Club.
Mr. Chairman, at this time, it would be appropriate to allow questions as to the witness's expertise or lack thereof by Mr. McCray.
Mr. McCree?
Well, Mr. Morgan, what we've heard about your experience in sound engineering. What is your educational background with regard to the measurement of decibel levels?
Mostly through just experience. Using an SPL meter. I wouldn't call that rocket science, but it's basically just reading a meter, taking it out to a sound source, and saying, just basically reading what the meter gives you.
And what type of meter is it that you use?
It's called an SPL meter.
And what kind of training have you had to utilize that type of meter?
I haven't had any training to use that meter.
Had no kind of training?
No, sir.
Okay. We're going to object to Is that the type of meter that you're about to testify that you utilize at this business?
It is.
Okay, we're going to object to this witness being admitted as an expert when he just testified he has no training with regard to this particular type of meter.
Maybe it's a matter of semantics. Mr. Morgan, what experience have you had using this particular instrument?
I've worked in quite a few nightclubs, and everything from churches to gentlemen's clubs to everything in between where you would need a sound system. It's a regular tool. It's just like I haven't had any training using a screwdriver either, but I'm quite adept at using it. It's a really basic tool, like I said, where at certain clubs I need to know what level the volume's at to make sure I'm not damaging anybody's hearing.
What is the name of this instrument again?
It's called an SPL meter for sound pressure level.
And what does it take to operate such an instrument?
You turn it on, and you basically look at the dial. It has what they call a reference microphone on the top of it, and it's built to basically pick up any sound. And then from that sound pressure level reading, it gives you a number in decibels.
And how common is it to use this instrument in your industry to determine sound levels?
Fairly common.
Well, if I may also ask,
Sure.
Is this something that instrument that must be calibrated?
No. It's a digital SPL meter. So out of the box, put a battery in, turn it on, you're good to go.
How reliable is this instrument?
I would, 100% reliable.
All right. Any further questions, Ike?
To your knowledge, is this a type of instrument used by law enforcement agencies to determine decibel levels in the enforcement of ordinances?
According to the manual on the unit, not only law enforcement, but health advisors, you would use it on a construction site to say, hey, this jackhammer is too loud. People should have soundproofing or, wearing headphones to protect their hearing, as well as sound engineers.
So it really doesn't take any expertise at all to utilize this instrument, does it?
No.
Just a matter of pulling it out of the box, putting in a battery, and turning it on. Is that what you testified to?
Yes, sir.
All right. If there's nothing further, members of the board, as we've discussed many times, the difference between an expert and a lay witness is that an expert can render an opinion. The laws of expert qualification are fairly liberal, and if you make a determination that this witness, by virtue of his training or his education or his experience, has a body of knowledge that you do not, which could be useful to you in determining the outcome of the issues in this matter, you may accept him as an expert witness. Again, I caution you, even though you accept this individual as an expert, you are not required to believe the expert's testimony simply because he or she is an expert. You are to use your everyday common sense experience in judging the quality of the testimony, taking into account the witness's demeanor, his ability to form an opinion, his training, education, experience, or lack thereof, and whether what he says makes sense to you. So, it is in your discretion. You can accept this individual as an expert. All that does is allow him to render an opinion on sound. What specifically do you want him to render an opinion on?
He's going to render an opinion about the equipment that was installed and the noise level that it will reach inside the club and the noise level outside the club with that system operating.
All right. So he could render an opinion on that if you so choose.
I'm going to overrule the objection, then,
Well,
and we will accept the witness as a professional.
All right, Mr. Morgan, thank you. Mr. Morgan, can you describe for the board the work that you performed? Well, first of all, the sound system that exists at Headlights, Mermaids, is that a sound system you're familiar with?
I am.
Did you, in fact, install that sound system?
I did.
All right. Have you recently attempted to determine the level at which that sound system will reach before it will shut off as a system because of the volume level?
Yes.
And did you also determine the ambient noise level outside of the club without the sound system operating at all?
I did.
Can you describe the work generally that you did to the club, to the commission, and maybe just quicker for you to
As far as
explain
the
it?
reading or as far as installing the sound system?
Well, you installed the sound system how long ago?
It's been a while, probably 6 or 7 years.
Okay. And you're quite familiar with this system
I am.
and how it will perform?
Yes, sir.
All right. If you can just describe for the commission the work that you did to determine the sound levels, we'll start with that.
Sure. Using the SPL meter that I've described before, I started with what you would call an ambient sound reading. And I went to the edge of the property line for the club on both sides.
Would you define an ambient sound rating for the board? What does that mean?
Ambient sound rating is if we were to not speak, or if we were to say just go outside and what you would hear. Ambient sound rating means not something that would be introduced by an outside source. I don't want that to sound misleading either. Traffic can definitely be an ambient sound leading, or an ambient sound, or say a jet flying overhead. But ambient sound is just the sound that's there without introducing a secondary source.
I'm not sure I understand that. Does the board do?
Let me see if I'm understanding it correctly. You're saying the ambient sound is the sound outside of the facility when its sound system is off. You're just
Yes, sir.
measuring the existing sound out there.
Yes, sir.
Okay.
And I took a reading basically outside the system with no music on. I went inside the club. I first had them turn the music on to the level where they said was their average. I then looked at the system and basically I turned the music up to a point of failure. On the amplifier they have it.
What do you mean you turn the music to the point of failure? You're going to have to translate for
Yes,
us.
sir. And when I say failure, the absolute loudest the sound system could operate before damaging one of the components or there's a safety on there, basically before the safety kicks in and turns the sound system off. So I went ahead and turned it all the way up to failure, the absolute loudest it could be, and then took a second SPL rating in the same two places. So the ambient noise rating, the minimum ambient noise rating I got was 45 decibels. This is from the fence, with my back to the fence at the edge of the property facing the club. The maximum SPL rating I got was 61 decibels. So between 45 and 61 decibels. Going to the highway and putting my back to the highway and facing the club with no music on in the club, the SPL ratings were between 56 and 82 decibels. The 82 decibel meter was basically when a car would drive by, it would bump the SPL rating up to 82 decibels. I then went inside and I had them play the music at what they called average. And I took a sound rating actually inside of the club at what they said was average, and that was 85 decibels inside of the club. I then took the system and, like I said, I turned the volume up to a point of failure. At that point, the dB rating reached 96 decibels. I then returned to the same place on the property line towards the fence with my back turned towards the fence and took a second reading with the music on at its absolute loudest it could be inside of the club. And that was the same exact reading between 45 decibels and 61 decibels. I went to the edge of the highway. I did the same thing again with the sound at its absolute loudest it could be in the club, and it was between 56 decibels and 82 decibels. There was no noticeable difference with the music on or off at the edge of the property line.
Can you tell me again where you took these readings? One was at the
Sure.
fence line.
What was explained to me would be the edge of the property line. There's basically a fence to one side of the club, and on the other side of the fence, I guess that's where our neighborhood is. I literally went and put my back to the fence as you know, to the edge of the property line. That's where I took my first rating. The street, I guess the interstate you turn off of to get into the driveway to the club, that's where I took my second reading. And with that, I had my back to the street facing the club with the SPL meter.
And so what you're telling us is you actually can't even hear the music when you're standing outside.
to my ears, I couldn't hear it when I got 10 steps out of the doorway, but according to the SPL meter, there was absolutely no change at all. Between the ambient noise level and the music at its absolute loudest, which justly means whenever there's a car outside, whenever there's basic sound you would hear outside, was louder than music leaking out of the club.
Any other questions?
This was done 6 or 7 years ago?
No, ma'am. These readings were taken yesterday.
Okay.
And that has been the same sound system in place since you've installed it some 6 or 7 years ago? You confirmed it was the same system?
It was the same components. They've rearranged things, but the settings I took yesterday are with what was currently installed in the downstairs there.
I have no more questions.
All right.
Mr. Morgan, again, what was the ambient sound level that was taken
The minimum
at all
was
the locations?
the ambient on the fence facing the club. The lowest rating I got was 45 decibels, and the highest I got was 61 decibels. On the interstate facing the club, the lowest rating I got was 56 decibels, and the highest rating I got was 82 decibels.
At the highway.
Yes, sir.
Okay, and then you said that you turned the sound level up
To a point
to
of
a point of
failure.
failure,
Yes, sir.
and your readings were what?
Exactly the same.
How could that be?
The sound system's inside of a building. Just like if I were to scream in this room right now, it would be very audible to you guys and be very, very loud. But if somebody was outside, they wouldn't be able to hear that.
Does the building, to your knowledge, have any soundproofing?
I have no idea. But from my experience, things like insulation, a brick wall will block sound.
So when the music was playing, however, you measured a decibel reading at the fence line adjacent to the residential area of 61 decibels. Is that correct?
The absolute highest rating I got at the fence line was 61 decibels.
Are you familiar with the Currituck County noise ordinance?
I am not.
Okay. So you then would not know that in a commercial or business establishment, 50 decibels would be the maximum allowed between the hours of 9 o'clock p.m. and 7 o'clock a.m.
I did not.
And you again measured a maximum decibel level with music playing adjacent to the residential area of 61 decibels. Is that correct?
The same rate.
I'm objecting. That's not his testimony. That was the ambient level that he measured with or without music.
Well,
That was his testimony.
I recommend you can explain what his testimony was, but I believe Ike didn't ask him Ike asked him what the readings were. Is that correct, Ike?
Yes.
Yeah,
I believe
okay.
the testimony was that the maximum reading when the music was playing was 61 decibels.
Is that correct, sir?
The same as without music. Yes, sir.
All right, but it was 61 decibels.
Yes, sir.
And it was the same whether the music was on or not.
Yes, sir.
Okay.
I don't have any further questions at this time.
No follow-up?
Any other questions from the board? Okay, thank you.
Thank you, guys.
Any objections to releasing this witness? Anybody have any other questions?
Just one last thing. I do want to admit into evidence the CV that we passed around, and he's identified it.
All
So.
right, so you've accepted him as an expert, therefore, I think the CV would be relevant to the file and should be accepted.
Thank you.
For the record, Mr. Chairman, the CV is accepted into evidence.
We accept the CV into evidence, yes, sir.
Thank you. All right. I'd like to ask Mr. David Liebengood to come up. You have to be sworn in.
Yes, sir.
Yes, sir. Please state your name for the record.
David Liebengood II.
Okay. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, sir.
And
E as a boy, ENGOOD.
And please give your residence, sir.
Chesapeake, Virginia, 605 Luray Terrace.
Can you describe for the board what your general professional experience is?
Yes, sir. I own my own company at the moment. I've owned this company for 11 years. It's ABC Industry Consulting in Chesapeake, Virginia. Prior to that, for 11 years, I was a special agent with the Virginia ABC Board and worked in conjunction with law enforcement as an agent. I worked in Virginia Beach, Norfolk, and also up in Herndon and Reston as a special agent. Prior to that, I got degrees from Radford University. I received my undergraduate degree in communications with a BS. I have a master's degree from Radford University in criminal justice. And I was a university police officer and went through the police academy there while I was getting my master's degree.
All right, Mr. Libengood, have you gone to Headlights and reviewed the site and taken any note of what you saw there?
Yes, sir, I did.
And can you describe the property, first of all, whether or not you saw any openings or windows where the public generally could view inside the building?
No, sir, I saw no windows that could be viewed from the inside. I actually walked around the exterior of the building, and there were 2 windows at the front of the building, but there were blinds covering those windows. The front door itself is blacked out, so you can't see through the front door. So there was no way anyone could see from the outside to the inside of the building.
Excuse me, Mr. Plumley, may I ask, are you presenting this gentleman as an expert witness?
I may introduce him as an expert on in the field of investigating these types of establishments, but I'm going to first explain some of the steps that he took, and then I'll ask that he be.
He's not been tendered as an expert.
I'll
so
tender him.
He is a fact witness at this point. He can say what he personally observed.
Before we give any opinions, we'd certainly want to tender him. Did you observe the condition of the property in terms of trash or debris?
Yes, sir. While walking around the building, I noticed no trash or debris on the outside of the building. The parking lot itself was in, I would say, average condition due to the rain. I think there's been a lot of rain down here as it's been in Chesapeake. There was a fence on the back property line that was talked about.
Let me ask you this: Did you look to see what view anyone would have of the building from the Acorn Lane street?
There would be no view from the building because of the back
So you did
fence.
look?
Yes, sir, I
Okay.
did look.
And what did you see?
A fence that was constructed up the property line.
Was there anything else to block the view of the
There
building?
was also trees and shrubbery up along the property line as well on both sides of the fence,
How tall is the fence, would you estimate?
approximately 8 foot tall.
And the condition of the building, how would you describe the condition?
The condition of the building is very good.
Did you also go in and view the interior of the building?
Yes, sir, I did.
And did you find any type of security system inside the building?
Yes, sir. When you walk in the front door, there's a lobby area, front desk, and at the front desk, there's a metal wand. So if patrons wanted to, or if the staff wanted to, as patrons were coming in, they could wand the patron for any type of metal objects.
Did you see or take note of any cameras, security cameras in the building?
Yes, sir. There were approximately 16 cameras in the building. The cameras were spread out throughout the building. There was a camera facing the front door, so when patrons came in the front door, they were on camera. There were cameras at the back of the bar area, and there was also cameras around the runway and where the customers sit.
Did the exit to the building have any cameras as well?
Yes, sir, coming and going. There was also exterior cameras on the outside of the building.
And were those in or near the parking lot?
Yes, sir.
Was there an alarm system for the building?
Yes, sir, there was. When we entered the building, The alarm had to be punched in with a code, and when we exited the building, the alarm also had to be set with a code.
Did you also see a device for scanning identification inside the building?
Yes, sir. I had them turn their system on, their computer system, and what it does is if you are a patron coming into the building, you first off have to be a member, but they can take your driver's license and scan it into their system, which they do, and it takes all the biometric information off the scan card on the back of your driver's license and enters it into their system.
And what is that information?
It would be their name, their address, their picture. It takes everything that's on that barcode and enters it into their system. And it also allows them to know whether or not they are of age or not, 21 or older.
Was there also any information regarding an application for membership for the club?
Yes, sir. Since this is considered a members-only club and not a typical, I would say, bar or restaurant, when they came into the club, they had to fill out an application for membership.
And what type of information do they have to provide?
On that application, they have to provide their name, their license number, their address, city, state, zip code, their occupation, their birth date, their phone number. There's also a question on the membership card. Have you ever been convicted of buying or selling drugs in the past 5 years? Yes or no?
Do they have to read any type of rules or take any other steps?
There are some rules and regulations of the club that are posted on the wall.
All right. Now, you also walked Acorn Street, and did you take note of the houses and the quality of the houses in that vicinity?
Yes, sir, I did.
And how would you describe them?
The homes parallel to the club on Acorn Street, I would say they were of high-quality homes. They were brick homes. The yards were very nice. The community was nice. Yards were mowed. Well-constructed homes.
Were there manufactured homes in the area?
I saw no mobile homes or prefab homes on Acorn Street.
All right. At some point, well, I think this is as good a point as any. I would like to tender Mr. Livengood as an expert in the field of compliance investigation and in the field of, I want to ask him specific questions about calls of service made to this club as well as other clubs that he visited in Currituck County. So I'm asking that he be admitted based on his 11 years of consulting in the field and his work with the ABC as an investigator in the field of secondary effects and and in the area of compliance, conformance with regulations and code sections in regards to the operation of bars and taverns and gentlemen's clubs.
Mr. McRae?
Well, we object. We've heard no foundation laid yet that this gentleman has any expertise with regard to those things that Mr. Plumley just laid out.
I would suggest the objection should be sustained. What the witness has testified to this point is competent and should be considered by you. Those are his factual observations, but I agree. I don't see anything in the curriculum vitae. Any other foundational questions you would wish to ask them, sir?
Yes. In the course of your work as an ABC agent, can you describe what you were asked to do as a matter of course in your job and the work that you conducted?
Yes, it would be similar, because we are in North Carolina and I've worked with your agents here. It would be similar as your ALE agents with your alcohol ABC board. When I was hired on, I was a law enforcement officer We did undercover operations in bars and restaurants, made arrests, also did compliance work with rules and regulations for restaurants and nightclubs, did compliance work with licensing the restaurants and nightclubs in Virginia.
Were you called upon to determine and to advise club owners and individuals working in clubs regarding compliance with local rules and regulations?
Yes, sir.
And how many of those types of facilities have you worked with in your past?
In the past 22 years, probably 500 or more.
And did you have you had experience looking into calls to law enforcement to determine the nature of those calls as an officer and as an ABC agent?
Yes, sir. I did a lot of work with calls for service with the Virginia Beach Police Department as well as with the Norfolk Police Department.
All right. I think he meets the requirement here. I would like to explore with him his testimony concerning an investigation he conducted on this location and a comparison he performed on a bar tavern in Currituck County as a comparison to look at both calls for service and police calls made to those locations, and also the general condition of and his observations of the general condition of those locations.
Well, I don't believe he would have to be an expert to do that. He can always say what he observed, and then the board can draw their own conclusions. But if I may further up, are you familiar with Currituck County Adult Entertainment Ordinance?
I have read it once, yes, sir.
Once?
Yes, sir.
Okay. Have you ever conducted an investigation, other than perhaps this, regarding compliance with the Currituck Adult Entertainment Ordinance?
No, sir, I have not.
All right. I don't think the witness should be qualified as an expert.
May I
Regard
ask
this
something?
standard, yes.
It's been brought forward before that we don't have any other adult entertainment facility in Currituck, so there's no way anybody could be.
Well, he can.
Use that.
You can give it such weight as you want. Ike may object as to relevance. If he does, we will deal with that time. But my counsel to you is, he does not have to be an expert to say, I observed this facility in such and such a condition, like, for example, you can't see in, or it was clean, or it was dirty, etc., on such and such a date. Then I observed another one, and this is what I observed there. That does not require an expert opinion. He's not rendering an opinion. He's saying what he saw. Whether that will be relevant, I guess we'll have to address when it comes in. But he is not an expert, in my counsel to you, on the Currituck County Adult Entertainment Ordinance, nor is he an expert on secondary impacts. He has given you information which, if you believe, could lead to your own conclusions as to whether there are secondary impacts or not.
Mr. Livengood, did you review calls for service?
Just first, for your record, Mr. Chairman, you need to rule as to whether to accept this witness as an expert or not.
I'm going to ask the board.
Were you adding to that, or were you moving on?
What I was, when to tender him as an expert is an interesting process, because I think the information needs to come forward to a certain point. I would like him to testify about research he did about calls for service at least 2 locations within the county to give this board an idea. When I say calls for service, I'm talking about calls to the sheriff's department for any type of activity at these locations, which I think bears upon significantly secondary effects. And whether he's accepted as an expert on secondary effects may not be of great importance if he's accepted for the purpose of identifying these calls and understanding the calls that he was reading, which, as someone with a law enforcement background to the extent that he does, I believe he would qualify to do that.
He could be qualified as an expert in law enforcement. I don't have any issue with that.
Yeah, I think that's where the confusion
All right.
is, because you had tendered him as a secondary.
I agree with that. Okay. Well, if I could tender him as an expert in law enforcement for the purpose of determining the basis for calls of service to these two locations that we're going to be discussing, I think that's what the board is called upon to compare, and that's why I'm wanting to do that.
I just have to object. I mean, what the testimony, I think what Mr. Plummer would like his client to the witness to testify to has to do with things that he's observed or investigation or research he's done. That doesn't rise to, it seems to me, a level of expertise in any particular type of field.
Based upon the curriculum vitae, and I think we're spending entirely too much time on this, based upon the curriculum vitae, you can qualify this witness as an expert in law enforcement regarding restaurants and bars.
Then at this
Nothing
time,
more.
Okay. At this time, I will overrule the objection and accept the witness as an expert in the
ABC compliance restaurants and
as
bars.
to being able to research and give testimony in ABC compliance.
Would that be in Virginia or North Carolina?
He is, I note, he is worked only with ABC in Virginia. He said he has done some work in North Carolina. I think your qualification is sufficient for the time, and Ike, if you have objections as the questions get asked, we'll do it. But I don't, certainly won't tell you how to try a case, but I don't know that you need an expert witness for what you're getting ready to do you?
Well,
Well, never mind. Let's move on. Okay.
Mr. Leidengood,
Yes.
Leidengood, excuse me. Did you visit another location in the county, Barry's Walnut Island,
Yes, sir, I did.
a bar in Currituck County?
Yes, sir.
Did you observe the condition of the area of that location, that establishment?
Yes, sir, I did. I
And first, tell us, what is Barry's Walnut Island?
It's a community.
I'm going to object as to relevancy of this entire line of questioning.
I think the issue before this board is the condition of mermaids, not the condition of any other establishment in the
Can I
county.
address that?
Please.
Thank you. Yeah, the court has asked the board to make a determination of secondary effects of the initial use, which is a bar and nightclub, and the amended use, the gentleman's club, and to compare those uses, roughly put.
Compare them with what? I'm not arguing.
The
I'm trying-
secondary effects of those two, and to
Right,
compare
right.
the two.
But it's only of mermaids or headlights now.
Well, we're in Currituck County. He's observed a facility in Currituck County, and he's comparing it.
I
The
understand.
weight of it is up to y'all.
Well, didn't he ask us to analyze the intended use, which was a nightclub? So we're actually doing both.
You're doing both, but it is, my counsel is, it is this facility, and I think the comparison is between the two uses of this facility, not comparison with any other entity in the county. For example, let us say, and I have no opinion and I don't want to denigrate Barry's Bar and Grill, but let's suppose that was horrible and was much less amenable to the public than mermaids. That's not relevant. Because it's bad in one place doesn't mean you have to allow it to be bad in another place, you see? And I'm not saying what they would do would be bad, but I think we're getting pretty far afield here.
Well, if I can address this, I understand and I appreciate the advice of counsel to the board, but the board has been asked by the court to make this comparison. There has to be some basis to compare it with. Right now, the county has presented evidence that there is no negative secondary effect associated with a bar, and I want the opportunity to refute that evidence and to put into evidence observations made of a Currituck County establishment.
Mr. Chairman, I'm struggling with relevance here. I want the truth to come out and everyone get their opportunity, but relevance I'm struggling with.
Well, if I'm understanding where Mr. Plumlee's trying to go, he's probably going to try and show that there is one bar that has police calls, has noise violations and stuff on the sheriff's record, and this location does not. Am I guessing right here?
That's the line.
So,
No explanation necessary. I just wanted to let you know. I was struggling with relevance.
so at this point, we had an objection. Is that correct?
Yes, and you must rule. You can overrule the objection and hear the testimony, or you can sustain the objection.
I agree with you.
I'd like to hear.
Okay, then I'm going to overrule the objection.
All right. Mr. Livengood, in fact, you visited not one, but 3 other locations, correct?
Yes, sir.
If you can describe the work that you did, what you observed with regards to your observations of these locations and the findings you made with regards to calls for service.
Yes, sir. I'll start with, since it was the first one I went to, I'll start with Berries on Walnut Island. When I went onto the island, I sort of drove around before I went into Berries to look at the conditions of the homes and what type of homes were back there, comparing them to what was on Acorn Street by headlights. What I noticed were there were a lot of mobile homes back there. There were prefabbed homes. There were actually mobile homes sitting on cinder blocks. So throughout that area, right beside Berries, there was a lot of trash outside on the grounds, on the property lines where Berries is. I also looked at the calls for services.
Let me ask you one more follow-up question about Berries. Did you go inside?
Oh, yes, sir, I did.
Did you observe any sort of security system or personnel?
No, there was no security system at the front door. No one ID'd me at the front door. I just walked straight in.
And what is your understanding with regards to security personnel at Mermaids?
There are security at the front door, and there's also a security personnel inside the establishment that walks and observes what goes on inside Mermaids as well as into the parking lot of Mermaids.
And you were going to mention the calls for service with regards to Berries and Mermaids. Can you describe what you found?
Yes, sir. On the calls for service, and I received these calls from service from the Currituck's Call for Service Center. The calls for service came from...
Go ahead.
Okay. The Currituck, the calls came from Liz Hodgins in Currituck County, North Carolina.
What did you find?
What I found was at Berries Walnut Island for calls for service from 2007.
I'm going to object. This is hearsay.
If I can address that, this is coming from an expert who has conducted research on this subject, and therefore I would argue that it gets beyond the hearsay objection.
He can render an opinion based upon that, but I think we also need him to say first that if it is in fact the case, that in rendering an opinion for experts in his field, this is the type of information that's routinely relied upon. I think Ike's objection is well taken, that just the documents by themselves are hearsay. The lady that made the complaint is not here in court, and she can't be cross-examined.
If I may, or the person that prepared the report. If
Exactly.
they wanted that testimony to be introduced, they could have well have subpoenaed that individual. That person is not here to be examined or cross-examined.
He can
could
say,
have filled up this room.
well, it's true. I think he could say that he has examined records at the sheriff's department, and based upon his examination, if that's kind of information that's routinely relied upon by experts. He has formed an opinion, and then he can render that opinion.
Okay, well, let me go back then, and first of all, we will sustain the objection. So now, Mr. Plumley, would you like to readdress?
Thank you. Mr. Livengood, have you formed an opinion with regards to the calls for service at Barry's Walnut Island?
Yes, there's,
And you formed
Yes.
an opinion?
Yes, I have.
Okay, thank you. And what is that opinion?
my opinion are that there are quite a few calls for service at Barry's on Walnut Island.
And what is the number of calls for service?
The numbers for calls for service on Barry's from 2007 to 2015 is 94 calls for service.
All right. And did you perform a review of records for mermaids?
Yes, I did.
And do you have an opinion with regards to the calls for service made to mermaids?
Yes, I did.
And what is that opinion?
There is not as nearly many calls for service. There are a total of 14 calls for service from 2007 to 2015.
All right. And did you look at the nature of the calls for service as to whether or not they actually related to those two establishments' actual operation?
Yes, I did.
And did you arrive at an opinion regarding the calls for service that actually related to the operation of the two facilities?
Yes, I
Objection,
did.
that calls for speculation.
That's what an opinion is.
That's his opinion.
Yes,
That's
it's
his
his opinion. You don't have to accept it, but it is admissible.
And what is the opinion that you have with regards to those two facilities?
There are still more calls for service with Barry's based off the class of the closed code and the type of calls for service than there are for mermaids.
And what is the number for Barry's?
For Barry's, again, the actual calls for service is 94.
And for mermaids?
For mermaids, the total calls for service is 14.
And after you've reviewed those calls for service, for those that are related to the operation of the facility, there are 14?
Yes, sir.
Okay. And so this is over the same time period?
Yes, sir.
All right. Now, in addition to the observations that you made at Mermaids, did you also speak to residents in the vicinity of Mermaids?
Yes, I did.
And what were the addresses of the residents?
112 Acorn Street, 121 Acorn Street, 9116 Currituck Highway, and 9086 Currituck Highway.
And what was the impression that you got in speaking to the residents of those four locations?
All four residents that I spoke with said there were no issues.
Objection as to what those persons may have said.
That should be sustained.
What were the
Thank-
impressions, don't repeat what they told you, but what were the impressions that you formed in after those conversations?
They had no issues with mermaids.
Now, were there other bars that you had visited in Currituck County?
Yes, sir.
And what were those locations called?
The other two locations that I visited was 198 Shortcut Road, which is, I believe, now called Geno's. I think it was used to be called Mule Days.
Any other
And
location?
AJ Gators.
All right. Did either of those locations have the security system that you observed, or a similar security system that you observed at Mermaids?
No, sir, not at all.
Were there personnel there to be at the front door, the security personnel at the front door,
No, sir.
or throughout the clubs?
No, sir.
I have no further questions to the witness.
I-
When did you observe the operation of headlights for mermaids?
That would have been on Monday.
This past Monday?
Yes, sir.
And what time were you there?
Between the hours of 4 and 8.
And they weren't open, were they?
No, sir.
So you didn't see them actually in operation?
No, sir.
You've never seen them in operation, have you?
Yes, sir, I have seen
Yeah?
them once in operation,
Okay, when was that?
a few years ago.
A few years ago?
Yes.
And this, at what time of day were you at Barry's Walnut Island?
Same time Monday, it was probably around 8:30.
In the evening?
Yes, sir.
And it was in operation when you were there?
Yes, sir.
And it's a restaurant, isn't it?
It's a restaurant that has karaoke, dance floor, live music. I don't know what your definition of a restaurant is. They did have food there. So,
They have tables where you sit and order food, is that correct?
yes, sir.
Right? People receive service at a table,
Yes, sir.
right? And do you typically, in your experience, find that a restaurant has a security guard at the door?
Yes, sir.
Oh, really?
Yes, sir.
And where else in Currituck County did you find a security guard in a restaurant?
You just asked me in general restaurants. In Virginia, there are restaurants.
Oh, in Virginia?
Yes, in Virginia,
Okay,
yes.
well, how about your experience in North Carolina?
Repeat the question?
How about your experience in North Carolina? What North Carolina restaurants, specifically in Currituck County, are you familiar with that have security guards at the door?
None that I'm aware of.
Now, Mermaids has not been open continuously from 2007 to 2015, has it?
Not that I'm aware of.
Right. So, actually, the service calls, where you said there was 14 during a period of 2007 to 2015, it's really a more limited period of time, is it not?
Yes, sir.
Now, with regard to residents you spoke to in the vicinity of Mermaids at 112 Acorn, who lives at that address?
The lady I spoke with, her name was Veronica.
You don't know her last name?
No, sir.
And
Or
where
no,
is-
wait, I'm sorry, it's Erica
and
at
where,
112 Acorn.
and where is that house in relation to the Mermaids building?
It is on the other side of the fence that we've talked about, beside 118. The house is directly behind Mermaid.
In fact, do we have the ability to put up a overhead map? Okay, from that map, can you show where 112 Acorn Lane is, or describe where it is for the board? Now, they're seeing what you're seeing. They can't see your fingers.
There
Right.
might be a mouse. Here is their mouse.
The mouth? I see something. Something's moving.
Well, Mr. Wood is doing
Oh, okay, okay. Yeah, the Acorn Lane is right here, running parallel to the club.
Right.
The club's in red.
And where's 112 Acorn Lane?
I'm assuming 112 Acorn Lane, here's the club. The back property fence is probably down a little bit further, because they're right there. I'm assuming that's 112 Acorn Lane.
Okay, you think that's 112, but you
Well,
don't
yeah,
know.
I don't have an address on there, so I can't.
I don't see a house.
Well, isn't that a house right there he's on? Yeah, there's a house there.
All right, and where is and who is the owner of 121 Acorn Lane?
121 Acorn Lane was Valerie. And that was across the street, right here, where that's 121 Acorn Lane,
Okay.
because it was
And where is 9116 Currituck Highway?
9116 Currituck Highway is well, where, I don't know where my little icon went. It's over on the other side. No, not across the street, but beside Mermaids.
Go south.
Go south, yep, right there.
And who's the owner of that property?
His name's David.
David what?
I don't have his last name. I just talked to him.
And where is 9086?
That's on the opposite side where the storage units are.
Okay, and who'd you speak to there?
Bob.
Now, you say that you walked down Acorn Lane, and in your view, there is no way anyone can see the Mermaid's property. Is that correct?
No, sir. Not directly standing in front of the fence. No, sir, there would not be.
Okay. But did you go into any of the homes and look from their windows and their perspective toward Mermaids?
No, sir, I did not go into their homes.
Okay. And that would include the two-story home directly behind the club. You did not go in that home and look out their windows to see what it is they actually can observe, did you?
No, sir, I did not.
Okay. And, let's see, I believe you said Mermaids was not operating when you were there?
No, sir, it was not.
Okay, so you didn't hear any music or make any comparison of the sound of music from the club in relation to Acorn Lane?
I did have them turn the music on and did make some comparisons from the inside, and I walked to the property line to the back fence as well as to the road.
And what was your decibel reading?
I didn't have a decimal reading. I just
so
said
you don't know what the sound level was?
No, I do not know the exact sound level.
Well, I don't have any further questions.
Okay. Does the board have any questions?
Did you research any of the calls for service at the other two locations?
I'm sorry.
Did you research any of the calls for service at Gino's or AJ Gator?
Yes, sir, I did. I extrapolated those calls for service as well if you need them.
I think that's what he's asking you. What,
Yeah, okay.
I'd like to see this. It'd be a flat tire.
So what was your opinion with regards to the number of calls for service at AJ Gators?
Okay, I'm looking for that, my sheet.
Want to make sure the same question.
Right. Okay, AJ Gators, from 2007 to 2016, there were 26 calls for services. And for Gino's on 198 Shortcut Road, from 2007 to 2015, there were 64 calls for services.
I have a couple of follow-up questions for Mr. McCree's questioning, if there's nothing else. You were asked about the sound, and you said you did not meter it. Can you tell us what you observed with regards to the sound when you walked away from the building with the sound going inside?
Yes, sir.
I'm talking about for Mermaids.
Yes, sir. From Mermaids, when I walked out the door with where they normally keep the sound level, when I got approximately 15 to 20 feet into the parking lot, I could no longer hear the noise. When I walked to the back property line where the fence was facing the club, I could not hear any of the music or noise coming from the club.
And you took a photograph of the fence, and if you can hand that to Mr. McCree. Here. And, yeah, that's your cup. I'm handing you a photograph. Is this a photograph that you took?
Yes, sir.
Is that the fence that you were describing, the property line at Mermaids?
Yes, sir.
Is that 118 Acorn,
Yes.
the house on the other side of that fence?
Yes, sir, that is 118 Acorn.
No further questions.
Mr. McCree, do you have anything else?
I do not.
Any member of the board?
Mr. Chairman, if I might, it was brought up the calls of service, and the board asked that you research those and you actually know what they were called for.
Yes, sir. I know exactly what the calls were for.
I'd be interested in that, and not to cause conflict or anything, but a call for service is probably a broad range of things, anywhere from a knife fight to I got locked out of the car.
Oh, you're right.
If we're going to address that, I think it should be addressed to that extent.
Okay, yes, sir. What I did off the call list that was provided to me from the Sheriff's Department, from the call center, any
Yeah.
traffic?
Excuse me,
Yes, sir,
which
I'm sorry.
location are you speaking to?
I'm just speaking in general now. Any traffic stops I took out that, I could tell were traffic stops, on the road. Any type of business check where they're just doing a routine business check of the business, I took out for all four of the places. So I was just looking at the calls for services that would have been from my looking at these in all sorts of different cities that would have had something to do with the business itself as it was running. Which one would you like me to start with, and how would you like me to give you the information?
Give me a second here. I don't want to drag this out too far. If you could help, please.
Sir,
Yes, sir.
let's start with mermaids. And how many of those calls dealt with any of the following? Intoxication,
Hold on, let me find my notes again. Everything got kind of scattered up here.
Let me ask you this, Mr. Livengood.
Yep.
Did you determine whether or not there were calls where there were actually reports taken or warnings or citations as opposed to no action taken at all?
Yes, sir. I actually put it,
Okay.
Is that a reduced number than what you've presented here so far for just general calls of service?
Yes, sir. That's even a reduced number for all the places.
all right, well, let's talk about mermaids right now. Have you got that information in front of you?
Yes, sir.
All right, how many calls over the period of time that you have researched this? I think you said that's going back to 2007, is that correct?
Yes, sir.
How many calls were there for alcohol-related offenses?
1.
How many calls were there for substance abuse, drug use?
0.
How many calls were there for prostitution, solicitation, sexual misconduct of some kind?
0.
How many were there for simple assaults of phrase, that kind of thing?
You have some phrase, and again, it's assault not in progress, so I'm assuming that's after the fact. But 2.
May I ask, were there any?
Just let me finish. Everybody can cross-examine based on what I've done. How many calls were there for ABC violations?
0.
Any other topic suggest themselves to members of the board?
Noise.
Yes, noise. How many noise violation calls were there?
Actual calls for service, there were 3.
3. And of those 3, how many resulted in a citation?
0.
Okay,
How many total was that?
3.
There was total for all categories.
No.
14.
He's talking about mermaids, noise. There were 3.
Total citations,
0.
Okay.
all 14
Okay.
incidents.
Yes. All right. How many actual citations from 2007 to the end of your research How many calls ended in citations at Mermaids?
0.
How many warnings were given?
0.
Okay. All right, now could we take the next, were there any other questions, topics from Mermaids? All right, could we now go to Mr. Nelms, Barry's, and go through something similar?
Yes, sir. Okay, there's again, from 2007 to 2015.
If you can step up to the
Oh, I'm
mic,
sorry.
it'll help.
Again, there was a total of 94 actual calls for services.
All right, so the first question, I think the board member was right on target. How many of those resulted in actual citations?
Two.
Okay. And how many of those related to alcohol offenses? Intoxication, public drunkenness?
Are we talking about actual citations or just calls for service?
Just calls.
Just calls for service. Nine.
You said, I'm sorry, what was the number?
Nine.
Nine.
That's
Nine.
just that, from what I,
And how many of those resulted in a citation?
one ticket was given for a fight in progress.
Okay. All right, I assume there was none for solicitation, prostitution, drugs.
None for solicitation or prostitution. Let me check on drugs. There were 2 calls for service for drug calls.
All right.
And the way y'all have it listed in your calls for service is it's drug information, and then it says not recent after. But there was 2 calls for
All right,
service.
did those 2 drug calls result in the issuance of citations or further criminal action?
On one of the drug charges, there was a report taken, but
Okay, no charge.
no charge.
What about noise?
Noise. Okay. $28 total calls for service on noise.
And how many of those resulted in a citation?
One.
All right. All right, if that's sufficient, we'll move to AJ Gators.
Do you want to keep hearing, or?
No, I'm satisfied. I just felt like if we were going to go down this road, it should be deciphered
Okay.
to actually what it was. I mean, there's a lot of difference between a knife fight and a flat tire.
Okay.
All right.
Mr. Plumley?
Well, did we want to go to AJ Gators as well and do the same analysis, or is there no interest in that?
They did
No,
not.
sir.
Okay, all right, thank you. I had no further questions. I think that was a follow-up question from a board member.
Correct. Okay. Any other questions from the board members would be proper, Mr. Chairman, at this time? All right, if there are none, then it would be proper, Ike, you can follow up on matters raised by the board members' questions, but only that.
I don't have any questions.
All right. Then we're ready for our next witness, Mr. Blondie.
Thank you very much. Thank you. We're finished, yes.
If the board does not have any objection, and Ike doesn't have any objection, then I think we should excuse this witness. He's free to stay or go, but anybody?
I have no objection.
All right. You're excused, sir. You're free to stay or go.
Thank you, sir.
The reason I raise that, Mr. Chairman, is these people are obviously being compensated, which is proper for their services, and if we're not going to ask him any more questions, we need to turn the clock off, except for counsel. That's why I wanted you to ask.
Turned that clock off a long time ago.
All right. I call Mr. Buddy Brown back up. I think he initially had been sworn in, but you may want to swear him in again.
How about a recess?
Excuse me, 1 minute before we start recess for 15.
You need to stretch.
This is my final witness.
How long do you anticipate this witness will take?
It would probably take a 30-minute or less direct.
All right, and then I assume we may have some rebuttal and arguments, and we have been here about an hour and
Take a 10-minute
15
recess.
minutes, so we take a 5 or 10 minute recess?
Yes, sir. 10.
Okay, thank you. Sure. Sure. Not about what the ultimate outcome could be,
Oh,
but
no.
a question about legal matters and evidential matters and things like, yes, certainly.
And that was the perfect rebuttal.
Here's the thing, I had it in my head.
That was the first time you and I met. In Sunday school, maybe.
Because it suddenly hit me that this was going to be.
Yeah, you did Sunday school for us there. Yeah, I've never forgotten. Where were you? Also, it was through real devices that happened in Washington, D.C. Real devices. Real devices.
College roommate. You're busy. John. I think it's to the point of them making a decision and findings in an order. I'd like to think that you're going to draft them or something.
Yeah, I would draft it on the decision, not understand law and deliberations. So what I'm gonna do is take that to the board, walk them through it, and first time they make this, they don't have authority, but they will do it. Yes, I think then I should take us through that.
Even if you have to have another meeting with them, go through an order with them, I think that's perfect.
Where am I taking? Where's this ship going?
Yeah, sorry.
Hopefully not to a hurricane.
What port are we pulling it in?
Oh, it's a port of call, all right.
Yeah, how about that cruise ship company that took those folks into
That's crazy.
hurricane winds and they knew it before they left? Wow.
Reaffirms the
You
fact
know,
that I'm
those
not going
things
to take
that
a
I
cruise.
have known nothing about large vessels, but I see these cruise ships and they're like little mini skyscrapers, you know. They're narrow and they're great big and tall, which was seems to me would make it very unstable. And to put one, that has to act like a sail, I guess, in that pipe, you know, when the wind comes on. That would be frightening.
As the captain said afterwards, we were always seaworthy. Makes me feel so much better.
Yeah.
It's pleasant.
It's always cold in this
I won't be
place.
taking a cruise.
Not in the middle of a
I don't think it's storm. What a place look like randomly has some like disease around or something.
I wouldn't mind taking one. Maybe on a smaller place.
Yeah, it'd be small to me, yeah.
Celebrity. Well, my parents just did one of those Viking cruises down the Long River.
That'd be something.
Yeah, they really like that.
I did a little harbor cruise in Norfolk. The little boat was fun. I don't know about one as big, like floating condominiums.
From Bern, Switzerland to Amsterdam, all the Rhine.
It's like a floating Swan Beach development. As proposed. 900 rooms.
They were one of those little barge kind of thing.
That was probably pretty nice, actually.
What's a CV?
Curriculum,
Vita,
resume.
Yeah.
I was just saying that.
Some lab work for resume. Well, I guess resume is English word for lab work. I'm very good at that. Very good at that.
You better.
He said they all went out of the Senate today, right? Okay, that's good. I don't have to go on. I was supposed to leave here and go straight to worship. Because the staff always wants people to get up and talk. Right. But, no, that, be there at 8 in the morning because they did some stuff for me.
So you think Bill's doing a good job?
Bill's doing a great job, and it's going to get lower. I mean, if we have to go on this pilot program. It may take 2 years, but when it does get lower, it's going to be at least 25% or lower.
I got you.
And we're done. We're hoping to do the purchase thing. I gotta look over a few things real quick. What do you guys think?
I'll probably put some on this point, some had to read. I think you just like create a road.
So on the last witness, we're pretty much.
Yeah.
Are they going to get there? Come in on this end? Once you miss
There's probably 1 month out of the year you should make that work. Yeah.
Somehow or another, I'd like to clarify, I think we were misunderstood about the ambient level that the noise outside.
Yeah, I don't think there was any confusion there. All right, let's keep going.
kids are gonna be mad because they're not gonna have their Valentine party now.
Uh-oh. That's the only day they want to come to school, right?
Yeah,
Yeah.
if I do it before lunch, I'll get in trouble.
Becky, what did you say about school, Virginia Beach?
Why would you get in trouble for lunch?
Because we're not allowed to serve snacks or food before lunch. 'cause then
They'll
they
probably be
make
closed by the
Valentine
time we get home tonight.
Really?
Still have time.
Oh, yeah.
Ruin their lunch.
Yeah. Like the food they serve on the sidewalk.
Thank you, David. I needed that. That was
That's
good.
Fridays.
I guess you're sharing these.
I am.
Oh, this is great.
I am.
Supper.
Oh, yeah, it's getting worse. It's all processed and heated up. They don't cook anything. Yeah. I mean, they don't, all they do is
good.
put it
Yeah, they're
up,
good.
heat it up. Everything they serve on is processed.
Mr. Woody, are you ready?
I'm ready.
Okay. Then at this time, I'll call us back to order, and Mr. Plumley.
Yes, sir. I'd like to introduce Mr. Buddy Brown, or Robert Brown. He's president and owner of Mermaids, doing business as Headlights. Mr. Brown, has Mermaids received a special use permit or conditional use permit from the county?
We have not. I know the judge, the judge's order was to issue one, but I haven't seen it yet.
After the court ruled in 2012, what did you believe with regards to the right to operate a topless nightclub and bar at that location?
After the judge's order in 2012, we believed that we were properly operating the nightclub at that location.
And have you
And it,
have you been operating since that time?
we have been.
All right. Have you spent any money for the improvement of that location since that time?
Objection not relevant.
That should be sustained.
And I'd proffer for the record, if I could, his testimony on that subject. Go
All
ahead.
right, let me explain, board members. First, Mr. Chairman, you need to rule on the objection. My recommendation is you sustain the county's objection in that whether he has spent money or not is not relevant to what we were ordered to determine and the Currituck County Unified Development Ordinance compliance. By proffering, that means he wants to make a record, even though we have overruled, since another court may look at this, Superior Court, he wants to put in the record what he would have testified to had the objection not been overruled. It is a standard procedure for courts to do that so that the record is complete on appeal. So my recommendation as your counsel is the objection be sustained and the evidence be proffered, and then we move on. You should not consider what he's about to testify in your deliberations. You're just allowing him to make a record for appeal.
Now, I guess I'm going to stretch it a little bit. We're ordered to rehear the application,
Correct.
and it's to be a complete rehearing. And we
Well, I
are
think
to
you-
also
I
address
think-
5 items.
Yeah, you are, and you're ordered, as I've been, correct me, counsel, but Judge Tillett's order is that you would accept, that the county accept an application, a new application, which they did in the year 2000. Is that correct?
That's correct.
Okay. All right, so then you would consider both a special use and a conditional use permit from the information given in the year 2000. In addition to that, you're supposed to make certain findings regarding, which are specified in the order, regarding secondary impacts for a bar and for an adult entertainment establishment. Is that correct?
That's correct.
Okay. So whether they have spent money in making improvements is not relevant to any of that, in my opinion.
May I object? Excuse me. I'm sorry, Mr. Morrison. May I add?
No, you're not sorry at all, but go ahead.
May I add to my position with regards to that point?
Surely.
What was remanded back to you was a complete package. It came up as an enforcement action. that had been appealed to the Superior Court. The county was attempting to enforce its Uniform Development Ordinance against this establishment to close it down, and did close it down for a period of time. That was appealed to the Superior Court. The Superior Court reversed the findings of this board and remanded for further proceedings. That arises out of enforcement. It has been our position from the beginning, even appearing before this board 6 years ago, that the county is barred from enforcing the ordinance against the club for its failure to enforce. It's a doctrine called latches. I won't get into it. But this is evidence and information about the reliance he made upon the county's further neglect in not holding this hearing for a period of 3 years now, that he operated and put more money into the facility. And that's the basis of why I want to put this in the record.
I understand why you want to do it, but this board has no authority other than to follow the instructions of Judge Tillett, which was, and correct me, I'm asking both of you, Judge Tillett ordered that we accept a new application as to whether or not this facility should be licensed under the special use permits or conditional use permits of Currituck County, correct?
And also, Judge Height's order must be obeyed as well, which says that it's unjust to enforce the UDO against this facility.
Judge Height's order, if I am correct, specifically ordered us to carry out Judge Tillett's order.
And to also follow the dictates of his order. That's correct.
Till such time as a hearing was held before the Board of Commissioners and Board of Adjustment, the county was not to enforce its ordinance relative to this establishment. It has not done so.
That's correct. That's my understanding.
If I may, it's also very important to recognize that Judge Height reversed the Board of Adjustment's determination that this establishment was in violation at the time of the enforcement action in 2010 and struck the civil citations. That matter is gone. There is no enforcement action underway.
Correct.
That is an entirely irrelevant issue and not before this board.
What was also ordered by Judge Height was that this county award a special use permit immediately, no later than 30 days from the issuance of that order, and that was not done. The county was ordered to supply the ABC of North Carolina certification that was done. That was not done. And also, under Judge Tillett's order, this proceeding was to be conducted as early as possible, and that has not been done.
Not an issue before this board.
I agree with your points, and I can assure you that this board is very sensitive to the fact that for 16 years they were not made aware of what they were supposed to be doing and their predecessors. But, and those arguments may have merit when you get to Superior Court, but for tonight, we are to follow Judge Tillett's order, Judge Height's order, to my knowledge, about enforcement not being brought against mermaids, has been complied with. It's another issue as to whether or not the county issued a special use permit, which was ordered by Judge Height. You don't have the authority to issue a special use permit.
Isn't that what's before us?
We have to do a rehearing.
You have to do a rehearing, and you have to consider these things, but
Staff phrased this presentation as a special use hearing.
We don't have that authority.
I understand. Well, there's a lot of confusion in what we do and don't have authority. But is that not what was presented by staff? Is that this was a hearing for a special use permit?
That's the application.
The brief description on the agenda at the very first meeting was special use permit request for an adult and sexually oriented business. Presently,
that's the application pending before this board.
Okay.
And on that, staff's first finding was that the board didn't have the authority to issue that permit.
And if I could add, once this proceeding is closed, it's anticipated that the staff, what is going on here is this is mapping out towards enforcement against this facility without following the steps set forth by Judge Height. That Board of Commissioners did not do it. They didn't follow Judge Height's order. And now we're just going through this cycle of going back up to the Superior Court to ask, why wasn't this done? It should have been done, wasting everybody's time and money. and harassing the establishment, that's part of the enforcement of the UDO. And
This
instead,
board is not enforcing the UDO.
instead of doing that, the county should follow the proceedings set forth by the court, so we're not in this loop of going up and coming back. But I would like to preserve this item, if I could,
Okay.
for the record.
I agree, you should be allowed to preserve it for the record, but it's my counsel that you should not consider it in your deliberations, what he's about to offer.
I'm going to ask a little bit more. Our charge as the Board of Adjustment is when we rehear it, we can also, or we are to act as the administrator and reach a decision.
You're to act as the administrator if there's an issue of interpretation or enforcement, but what is before you is not enforcement, has it been, and is to whether or not they should have a special use permit or a conditional use permit. That's what's before you. Do we have Judge Height's order? Can we put that on the screen?
Yes, hold on a second.
I put Judge Tillett's order on the screen first, excuse me.
If you would allow me to finish,
Sure.
it's two separate things. The order tells us to rehear it.
Right.
And in that, we are to have 5 specific findings also, but we are to rehear the case.
My understanding is you're to rehear the application, but we can have input from council. You're to hear the new application, the year 2000 application. All right, so we got, I can't read it.
It says, the order says the matter be remanded.
This is Judge Tillett's order.
Well, I'm sorry. Let me get Judge Tillett if I could. And
Don't we all agree that Judge Height's
well,
said
Judge
go
Height
back and
puts
comply?
Judge Tillett's order in his order. That's what I was reading from.
Yeah.
Yeah.
But,
All right.
but
Which is, it's, I've got Tillett's order on the screen, which is in Judge Height's order.
All right, let's go to what, can you blow that up anymore?
I can. What do you want to?
Let's go to what Judge Tillett orders us to do, not the findings of fact, but just the order.
Starts right there, Ben.
All right.
it says the matter be remanded to the Board of Adjustment for rehearing, and that the Board of Adjustment consider the petitioner's application. So it says rehearing and consideration of the application.
All right, and it's an application not only for a conditional use permit, but for a special use permit, which we all understand this board has had no authority to do, but which they will because they've been ordered to do so.
Well, the court can order the permit itself.
But the court has not done that.
And the court directed that the permit be issued within 30 days of its order by this county.
That was Judge Height's order to the county.
That's right.
All right, not to this board. Okay, now, and you may well have a good point when you get to Superior Court on that, but, all right, so can we read this? All right, the Board of Adjustments shall consider the petitioner's application pursuant to, was that section 1304, and make specific findings of fact regarding those things. All right, and we will do that. And then he goes on, the Board of Adjustment in the alternative shall consider the petitioner's application pursuant to another section of the UDO and make similar findings. Ben, if you could go back up, scroll up. All right. All right. The petitioner, let's look at number 2. The petitioner is to file, and the Currituck planning staff is to accept a new application for a special use permit. Okay. So, and that did in fact occur in 2000, and that's part of the record, right?
Correct. That did in fact occur.
All right, and then number 3, the Board of Adjustments shall consider the petitioner's application pursuant to 1304, and then make certain findings of fact, and then you consider the petitioner's application pursuant to another section and make those same findings. And then what does it say, number 5?
Then it says that also the Board of Commissioners rehear the
Yeah,
application.
all right, which we don't have
pursuant-
anything to do. What does number 5 say? I can't read. Go back up. What does
Number 5 is the matter be remanded to the Board of Commissioners
Okay.
for hearing
All right.
pursuant to Section
All
808.
right, we're not concerned with the Board of Commissioners. So, my interpretation is the petitioner was to fill out a new application and the county was to accept it, which was done in 2000. That is the application and the only application we're considering. And then we go on to consider the application under 2 different sections of the UDO and address specific inquiries the court told us to. That's all we're doing. And then we render an opinion on that.
So we are to rehear the application, which is what we're doing.
We're hearing the new application.
All right, we're hearing the 2000
Yeah.
application.
Yes.
Not anything more
No.
recent than 2000.
No.
Well, that's a lot of interpretation from council, but, you know, it's the board that must interpret the order that's been given by the court, and the court is saying it be set for rehearing and that they consider the application. That's the order that's worded.
What
in
other
front of us.
application would we consider other than the new one in 2000?
Regardless of the application for consideration, it's also a rehearing. That's the point that I'm trying to draw from that.
It's clear it's a rehearing of the application, and the application is referenced in paragraph 2 of Judge Tillett's order, which is the special use permit application that the staff is to accept. It was accepted in 2000. There is no other application pending before this board.
The interpretation is for the commission to make. The attorneys can debate it, but it's for it's their decision.
All right, I've given my opinion, and I haven't heard anything that makes me want to change my advice. But council's correct, you don't have to accept it, and it won't hurt my feelings. but you still have to pay me for it.
The clock is running.
Is this new information relevant to the 5 points that we're considering in the application?
It is, let me process that question. It is information about the improvements made since Judge Height's ruling in 2012 and the amount of money he spent, which applies, in my legal view, to the latches argument that we are making. If your counsel is telling you you can't consider our latches argument and you're in agreement with that, then I'm asking that this information be proffered as part of the record for the court to consider whether or not that should have been determined by y'all.
And
Now,
I agree.
you've brought up a point that I wanted to get clarification of. You said that we were not expected to consider the doctrine of latches.
Correct.
Not that we should not or cannot, we're not expected to.
I think you cannot. I don't think you have that authority.
Okay. I've got 3 attorneys, and I bet I'm going to get varying answers.
Yeah, but I'm the best looking. and I am telling you that you are not to consider the doctrine of latches. You can allow him to make evidence for a superior court judge to look at, and if the superior court judge says I'm wrong, the evidence will be available just like it had been introduced, and then that judge can consider it, and he can do with what he wants. The case is obviously not going to end in front of you, but you are to enforce and interpret the Currituck County Unified Development Ordinance, and there is nowhere in the Currituck County Unified Development Ordinance that the words latches is mentioned. Okay, so and that's a pretty sophisticated legal argument. You have to weigh the merits of diligence. You have to weigh equitable remedies.
We have done that as this board.
Well, you haven't weighed anything yet because you haven't gone into
I think what he's
deliberations.
saying is,
In prior cases, we have.
I believe this was introduced into evidence was the minutes from a prior Board of Adjustment.
I came in without objection. That's correct.
And I believe that the board at that time considered latches.
Well,
That, if I may, I was there. That was an enforcement action. Has nothing to do with what's before this board now. Has nothing to do with making secondary impact findings. It had to do with the issues as to whether the county in 2010 should have enforced its ordinance and issued civil citations.
But what the court did upstairs in the Superior Court was say it's remanded back to the Board of Adjustment for proceedings and findings not inconsistent with this order. That's just Judge Height's order, Judge Tillett's order of May 99, and Judge Grant's order of 06. So all of the rulings and determinations made and findings made, they're to be consistent. And he found that it would be unjust to enforce the ordinance against this location for the reasons he set forth in his order.
but there's no enforcement issue in front of you. It's whether the permit should be granted or not.
Okay, and that's where I'm getting to. As this board, we're supposed to use layman's insight into the law and apply it in a fair and equitable manner. So,
And
am I incorrect in
no,
that?
you're correct. But the only thing I'd say, the only law you're applying, though, is the Currituck County Unified Development Ordinance,
Right, but
as it existed in 2000, right?
does maybe I'm misunderstanding. I did not see where we had to rule it only with the information as in.
The application was received in the year 2000.
Correct.
So it would be the law that existed in the year 2000, which may be more generous or more restrictive, I don't know, to the applicant. I suspect it's probably more generous. But that was, the court ordered, do this now, do this in the year 2000 by the law that exists right now, okay? So that is my opinion. I think the short answer here, Mr. Chairman, is we've spent more time arguing about it than it's going to take for him to present the evidence, and let him put in the evidence for the record about how much money Mr. Bryan spent, and then we can move on to something else. And my advice to you, how much money he spent or did not spend is not relevant to your decision.
What's the feeling of the board? Should it be allowed?
I'm comfortable with listening to it just from the point this, I think John made it clear that this will be revisited. And if the judge wants to hear this, it'll be there for him, otherwise it won't be, unless he goes back to these other judges' rulings.
So you're saying to sustain the objection, but allow it to be preserved in the record?
Absolutely.
Is that,
That's what I'm
or
saying.
does,
I'm good with that.
I'm good with that.
okay. Then we will sustain the objection, but allow the
Proffer.
proffer to be included in the record.
Thank you very much. All right. Mr. Brown, I believe I asked you that you explained that you made expenditures on the club. How much were those expenditures?
You had asked me if I made expenditures on the club. Yeah.
That's right.
So, yes, after the judge's ruling of 2012, and several months later after the county dropped the appeal, where they appealed Judge Height's ruling, and if sometime after that we continued to operate, we spent $106,000 continuing to make improvements in the club with the club and equipment.
All right. Now, you hired a professional named Lauren Berry to perform a market analysis, correct?
Yes.
And she was tendered as an expert in that field to this board, correct?
Yes.
All right. And you hired Mr. Libengood to analyze the calls for service, and that information has been provided to the board, correct?
Yes,
And as well as Mr. Morgan?
that's right.
Mr. Brown, how many adult nightclubs do you own and/or operate?
10.
And how long have you been in the business of operating an adult nightclub like Headlights?
Over 20 years.
Have you also owned regular bars and nightclubs?
Yes, owned Levels in Elizabeth City.
And how long did you own that?
13 years.
Have you attended any classes or workshops on the subject of secondary effects?
Yes.
And how many of those classes have you attended?
In the past 20 years of owning gentlemen's clubs and nightclubs, I've attended many legal panels, workshops, classes, seminars given during bar nightclub expos, the adult club executive conventions, annual conventions concerning secondary effects, alcoholic beverage control workshops.
Have you ever testified before any legislative committees?
Yes.
And what are those committees?
I'm the vice president of the Virginia Nightlife Association of Virginia, where we work with local businesses and the Virginia legislature on new bills concerning regulations for bars and clubs, club businesses. The most recent one being Senate Bill 488, a food to liquor sales ratio, which is part of the state's public safety agenda in Virginia. I also work with the city of Elizabeth City in meetings, giving input and advice on the implementation of adult ordinances.
And did that, in that work, did you consider secondary effects?
The implementation of the ordinances and regulations are to help prevent secondary effects.
That was Passatank County, not the city of Elizabeth City, wasn't it?
Passatank County. I work with Mr. Morrison on that.
All right. So did you provide expertise to Mr. Morrison?
Yes, I did.
I would like to tender Mr. Brown as an expert on the subject of secondary effects on a tavern or bar and as well as a gentleman's club.
I
I object. I mean, the fact that Mr. Brown may have lobbied on behalf of his businesses does not seem in and of itself to render, to lead him to be an expert in secondary impacts of adult establishments.
Did we not already rule on this?
Not from him. You've ruled on others, the police officer.
In prior meetings, I thought we.
You
I
may
don't
have read
think-
about it in the proceeding that you took home and read, the transcript, but I don't
Let
think.
me ask you, have you ever testified before the court as an expert, before any court as an expert?
We attempted to testify as an expert at the county commissioner's hearing.
No, in a
but
court,
no.
in a court of law.
In a court of law,
Superior court, district court, something like that.
on the
Secondary impacts.
secondary effects. I have not.
Okay. Members of the board, my advice is the same as I gave you before. If you believe this witness has, by virtue of experience or education or training, a body of knowledge that would be helpful to you in determining relevant facts of this case, you may accept him as an expert. He has testified, he has attended numerous workshops, had some training on this within the adult entertainment industry. If you believe that, that would be sufficient to be an expert. Again, I caution you, if you accept him as an expert, that just simply means he gets to render an opinion. You're not required to believe that opinion. And in addition to the other matters of scrutiny you should bring to any witness's testimony, including that of an expert, is bias, prejudice, or interest in the outcome of the proceedings. Mr. Brown is the owner of the facility. So you could bring that to bear in considering his testimony if you accept him as an expert.
And I would only point out, in addition to what Mr. Morrison has said, that in many, it is quite common in courtroom proceedings for parties involved in the particular litigation to be qualified as experts, and the weight of their testimony weighed by the finder of fact.
That is correct. Comes down to this, does he know more about it than you do, you think, in terms of secondary access?
I would agree to accept that as an.
Okay, all right.
Okay.
And so we've also, for the record, and the county would be keenly interested in this, and I'm sure we'll hear about it, and it's a reasonable consideration you must make. How much is his testimony slanted, if any, by the fact that he is the applicant? Okay. All right. But in terms of him being able to render an opinion, he can. All right. All right,
Okay.
so the witness is accepted as an expert.
Okay, thank you very much.
Good.
Mr. Brown, have you ever performed any review or investigation regarding secondary effects in the vicinity of mermaids trading as headlights in Currituck County?
Yes, I have.
And what did you do?
In 2010, I performed a census within 1,500 square feet. I mean, it's 1,500 feet of the business mermaids.
Okay. And what did you meet with individuals living in the area?
Yes. Over the course of about 3 days, was knocking on doors. We went to every house within 1,500 feet of mermaids, and out of all the doors that we knocked on, 31 people answered the door. Out of the 31 people that answered the door, 29 of them agreed to take the survey. Census is what we're calling it.
And is this a copy of the census?
Yes, it is.
You can hand that to Mr. McCree. Do you have a copy of it yourself?
We're going to object to the admissibility of,
On hearsay grounds.
yes, this so-called public opinion survey on hearsay ground.
Okay, Mr. Chairman, wait a minute, don't anybody look at that yet.
Hey, Donna.
Okay.
Excuse me.
All right, let me look at it. You just old. Thank you. Okay. Counsel, if you would, looking at what is being offered, there's a summary on the first page, but
Yes,
then there are a number of, like, fill in the blanks that ask questions: who your name is, where you live, and how long you've lived near mermaids. That I understand the hearing is going to occur October 18th, 2010, to decide where mermaids can continue to operate at their current location. I do not oppose the continued operation of mermaids in its current location. I've not experienced any negative secondary effects, etc. And then there's a signature line, and it is signed by some individuals. It would appear to me that inasmuch as Mr. McCrae cannot cross-examine a piece of paper as to whether it's authentic, the circumstances under which it was made, that these would be hearsay and should not be accepted. However, since the witness is qualified as an expert, I think he should be allowed to say that he has taken a survey when he took that survey, and that based upon that survey, if it is the kind of thing that is normally relied upon in this industry in forming an expert opinion. He has an opinion and what the opinion is. But as to actual statements of individuals who are not here subject to be cross-examined, it would be my opinion that is hearsay. All right?
So the objection by Mr. McCree is sustained?
I think it should be sustained as to individual statements. Now, Mr. Brown can testify as to what he did and how he conducted a survey, and then based upon that survey and maybe other factors, he has formed some sort of opinion, and he can render what that opinion is.
Okay.
And if I may just proffer of this particular item.
Okay.
All
All right. Let's mark this as petitioner's exhibit, whatever it is, and our applicant's exhibit. What number is that, Madam Clerk?
I believe this will be number 6.
Okay. So, Mr. Chairman, applicant's exhibit 6 has not been received into evidence. It is marked for purposes of identification only. It is not to be considered by you, but it has been proffered, just like the last statement.
Okay.
Oh, sure. Yeah. Yes, you can have it back.
Here, I'll leave that with you in case you have any questions.
No, I don't. You can have it back. Okay. All right. I believe we're ready to proceed. Mr. Plumley?
Mr. Brown, in your effort to arrive at an opinion regarding whether or not there were any secondary effects, did you also arrive at an opinion regarding the acceptance of the operation of mermaids in the community, and what did you base that opinion on?
Yeah, secondary effects. What's happening within 1,000 to 1,500 square foot of a nightclub or a gentleman's club or any place with alcohol is the most important facts that you can gather. The way I gathered them was I personally went to each and every person's door and had them fill out a survey. Each person was notified so that it wasn't biased. They were notified that there was going to be a county meeting here, that they could come down and oppose the business. Each individual was able to check off whether they had secondary effects or not, or make comments on that.
Did you arrive at an opinion whether or not they believed there to be any secondary effects or not?
My opinion, and from the information I gathered from everybody on Acorn Lane that took the survey and within 1,500 feet, that there were no secondary effects of the business operation of mermaids being there, including meeting with the homeowner association.
Now, based upon your experience and your investigation and your collaboration with Mr. Morgan, Mr. Livengood, Mr. Pastor, who testified a couple of meetings back, and Ms. Berry, do you have an opinion as to whether or not there are any negative secondary effects associated with the topless nightclub as opposed to a bar tavern?
Well, based off of Mr. Livengood...
Do you have an opinion?
Yes, I have.
Okay, and what is that opinion?
Well, to go to Mr. Livengood's results on calls for service, to go to his results on calls for service, it was evident that there's more calls for service at a bar with entertainment, a nightclub, a bar with entertainment. Generally, what we're talking about is bands, live bands, DJs, karaoke, live music, which makes nightclub bar venues louder than a gentleman's club. And from his investigation on calls for service, can you repeat that question?
Right. The basis for your opinion that there are no more secondary effects, no secondary effects with the gentleman's club, you were explaining first, and I'll take you through that. You talked about Mr. Livengood. What about with Ms. Lauren Berry and her determination?
Before I get away from Mr. Livengood, I just want to say that I think that there's been a lot of information out here in this county, and there was a lot of questions to Mr. Livengood, and I believe that it's very telling that that information hasn't already been brought forward to anybody on the Board of Commissioners or anybody to the Board of Adjustments from the county, and I think it was evident tonight that there's a reason why.
But beyond the conclusions to be drawn from the information, you're saying in support of your opinion, what observations did Mr. Livengood talk about that support your opinion?
Well, he made the observation that there are the conditions around our establishment are cleaner, and the building is more well kept, that the neighboring houses are cleaner and more well kept, and that there was a new house under construction within 200 feet.
In fact, wasn't there a home recently constructed behind Mermaids?
Yes.
Is this a photograph?
Yeah, that is.
I think there are a few photographs, but I don't want to introduce all of these. I'm just going to take the first one. And with regards to his discussion about the fence, did that also weigh into your opinion? And the view from behind?
Yes, Mr. Livengood, and he's not a sound expert, but he did his own sound test where he went out of Mermaids, and like the sound expert, the ambient noise outside of the club, he determined to be the only noise that he could hear, and that you could not hear the sound from the club where he was standing at the fence. And where he determined that there is an 8-foot fence, there is bushes, there are trees, there are things blocking visually the club and the club from the houses in the back.
And did you also research actions of the Board of Commissioners taken in 2006 concerning the club when it comes to forming your opinion?
Yes.
What did you find?
So, in 2006, when the lawsuit was voted, when it was voted
Objection.
4-1.
Objection's not relevant.
If I could address relevance, if he could complete his statement, what he's talking about is the discussion that was by the Board of Commissioners itself about this establishment, and these statements were made publicly, and that is also weighing in to his opinion that he's reached about secondary effects if he can complete his testimony.
The object is hearsay.
Yeah, why wouldn't that be hearsay, what the Board of Commissioners said, if they're not here to testify about it and be subject to cross-examination?
It's hearsay, but it's used in the formation of his opinion, and I believe it's admissible for the purpose of showing the factors weighing on his opinion.
Did you consider the statements of the Board of Commissioners?
I read the statement of the Board of Commissioners.
All right. And of those factors which would normally be relied upon by experts in your field in rendering a decision?
Yes, the statement that was made.
All right.
Yes.
But my recommendation, you allow it to come in not as substantive testimony, that is, testimony you believe to be true, but that he considered this, which was a reasonable thing to consider in forming his opinion.
So the objection is overruled.
Yes. But there's a limited use to be made about what he's getting ready to say.
So you were talking about a vote in 2006 by the Board of Commissioners.
Yeah, so I'm going to vote in 2006 by the Board of Commissioners where Commissioner Gregory stated that where they agreed to dismiss the lawsuit against Mermaids, and Commissioner Gregory stated that there hadn't been a single complaint against Mermaids and that there still hadn't been.
And with regards to the the type of club that's operating. Mr. Livengood described the security system. Are you familiar with the security system inside Mermaids?
Yes.
And what is that? If you could summarize it quickly.
So, in the club, there's a security system. First, when you walk in, there's a metal detector. Past that, in headlights, you have to be a member of the club. So if you're not a member, you have to be signed in by a member and be a guest. So once we sign a member up, we scan their license, which takes a copy of their information and puts it in the computer. That stays there until they're terminated. It also makes a copy of the picture of the ID, and that if we have any issues that arise, that information is available for us or any authorities that might need it.
And does each individual fill out a form that looks like what I'm handing you?
Yes.
And what's on that form, if you could read it?
On the Headlights membership application form is a membership ID number. It says that the information will be kept confidential between the club and the member of Headlights. Name, license, address, city, state, zip, occupation, birth date, phone number, radio station. And the reasons for some of those questions are it's a social club. We continue to ask if they've been convicted of buying or selling drugs in the past 5 years. And if no drug conviction comes up on a criminal background check, the application, yes or no. And if a drug conviction comes up on a criminal background check, the application will be denied.
And have there been instances where people have answered that in the positive?
Yes.
And were those people denied membership?
Yes.
All right. And what else? Anything else?
It just goes forward to have us that they understand the rules and regulations of privileges governed by these sign.
In addition to keeping the patrons' names on file, are the entertainers tracked in any way?
Yes. Most gentlemen's clubs are regulated by city and county and state ordinances, which also make them safer than bar nightclub. For example, the wording for the purpose of the regulations for Currituck County stated in 2010, when I read it, that the purpose for those regulations was to eliminate possible secondary effects. So in those regulations, they require that the business owners get licensed every year and be approved by the Sheriff's Department and have investigation by the Sheriff's Department.
So you're saying the individual owners have to list their names with the Sheriff's Department?
Right. That's not a typical. I haven't seen that anywhere in any of the cities that we've dealt with, done business with, or people that I communicate with in the industry.
For bar night
for a gentleman's club.
For a gentleman's club.
Right.
And so your name is with the county sheriff's office, and a criminal record check was done.
A background check by the Sheriff's Department, right?
Okay.
And in addition to that, we've licensed over 150 entertainers since 2010, and each entertainer has to have a background check done by the Currituck County and pay $50. And if they fail that background check, they wouldn't get an entertainer's license.
And without an entertainer's license, can they entertain at the club in Currituck County?
They cannot.
And as part of that, is their information kept on file in Currituck County in case of any investigation that needs to be done on these individuals?
Yes.
All right. And does Mermaids doing business as Headlights serve food? Yes. Does Mermaids hold an ABC license?
Yes.
Is the ABC license monitored?
Yes.
Are there security personnel kept on site during open hours?
Yes.
And how many?
2.
All right. And where are they? What do they do, and where are they stationed?
One would be situated at the door, taking IDs, approving memberships, and the other would be stationed on the floor and would float from the floor to the parking lot. He makes his rounds.
All right. And are there cameras, security type of cameras, kept on the at the facility, maintained?
Yes.
And how many cameras, and what are their locations, if you can explain?
We have 16 cameras. We have cameras in the parking lot, cameras inside the building, on the bar, on the floor, near the stage, and at the front door area on the entrance and exit.
Is anyone from the outside able to see inside windows or other openings into Mermaids doing business as headlights?
No.
Are there any pornographic materials generated or handed out or distributed at that location?
No, there's not.
And have there ever been?
There has not been.
And is your opinion with regards to alcohol consumption, do you have an opinion with regards to alcohol consumption at a gentleman's club versus a bar or nightclub?
Yes, I do.
You have an opinion? What is that opinion?
In my experience, my opinion is that in nightclub and bar patrons, specific to alcohol, when you go to a nightclub or a bar, you're going for a birthday party, you're going out to see the band, you're coming out for karaoke. It's more of a party environment, and that creates more intoxication than with a gentleman's club. That is a more laid-back atmosphere. It's quieter. The patrons generally come to view the entertainment and also have a few drinks, but it's not as intense of a party atmosphere as a bar with entertainment.
And with regards to assaults and fights and that type of behavior, do you have an opinion with regards to experiencing that type of incident at a bar versus a gentleman's club?
Yes.
What is your opinion?
In my opinion, my experience and opinion is that in a nightclub, bar, have higher rates of fights, assaults, arguments, and that's mainly due to the commingling of males, females, boyfriends, girlfriends, wives, husbands. That is that causes a lot of altercations in itself. And in addition to that, the noise from bands that come in with the drums and the percussions and DJs that set up 20 speakers when they hit the dance floor. So the dance floor and entertainment side of it also lends to that.
Are there bands that perform at Mermaids?
No.
Or DJs?
No.
Now, you have reviewed and heard the testimony of Ms. Berry regarding real estate value. With regards to, does that also play a role in your opinion with regards to Mermaids compared to other establishments?
I think if a bar, if a gentleman club is creating Blythe, putting obscene wording on their signs or not maintaining their building, that would generate a situation where you wouldn't want to build your house near it.
All right. And has that taken place at Mermaids, to your knowledge?
That has not.
All right. And there are regulations that you mentioned in the operation of the Gentlemen's Club, which are different than a bar. For instance, is a patron and the proximity of a patron to an entertainer, is that regulated for a Gentlemen's Club in Currituck County?
Yes, in addition to the licensing of the entertainers and stuff, part of the regulation for Currituck is that you have to be 10 feet away from an entertainer during a performance if they're in a state of nudity, in this case meaning topless.
And are there other restrictions during those types of performances?
That a patron can't tip an entertainer during a state of nudity.
All right. Is there another sexually oriented business within 1,500 feet of Mermaids?
There's not.
Is there a school?
There's not.
A public library?
No.
In 1999, was there another adult business within 1,000 feet of Mermaids?
No.
Or a church, synagogue, or house of worship?
No.
Or a public school or state licensed daycare?
No.
Or a public playground, public swimming pool, or public park?
No.
Have you also reviewed county records to determine whether there are any alternative locations for a sexually oriented business in Currituck County?
Yes, I have.
And what did you find? What is your opinion with regards to any alternative locations for a sexually oriented business in Currituck County?
There were no alternative locations when we did our study.
All right. And did you more recently, in 2015, request the county provide you a list of alternative locations for a sexually oriented business within Currituck County?
Yes, we inquired to the county and asked for any locations that an adult-oriented business could be open.
Did they provide you alternative locations?
They did not provide any alternative locations.
All right. You've heard Ms. Collins testify to the board about her objections. Had she ever come to your facility and made direct complaint to you?
She has not.
All right. Has the county ever made you aware over all this period of time that Ms. Collins had any objection to the operation of your club?
They have not.
I have no more questions.
Yes. Mr. Brown, with regard to this, with regard to your so-called public opinion survey, you say you visited every household on Acorn Lane?
Yes, I did.
Well, explain, what does households in coverage area 64 mean?
Those were the amount of houses that were in the area that we went to.
But you only surveyed 29.
Only 29.
Correct?
Only 29 answered the door.
Okay, so you didn't actually talk with or interview every household then, did you?
No, over a 3-day period, 29 people answered the door.
Right. So that's not everybody, is it?
It's not. It's almost everybody on Acorn Lane, though.
But it's not everybody. Is that correct?
That's correct.
Now, you heard the testimony of your expert, Mr. Pastor from Oklahoma, a few weeks ago, did you not?
I did.
And you recalled his testimony with regard to this so-called survey?
Yes.
And he said it actually was a census. Is that correct? That's, I think, a word you've now used tonight. Is that right?
Yes, that's correct.
And you also recall Mr. Pastor at that time testifying that this census was not reliable in his opinion?
I recall him saying that.
Yes. Now, please describe your consultation with, I guess it's Pasquotank County, regarding its sexually oriented business regulations.
In Pasquotank County, I sat in on a meeting with Mr. Morrison and the board at that time when they were generating their new adult regulations for the county. I had some information for them that I handed up to them, and spoke with several of the people on the board, including Mr. Morrison.
Did you make some recommendations to them about how to limit secondary impacts from sexually oriented businesses?
I made recommendations to them mainly on the rules and regulations of the operation of the club.
Did you make any recommendations with regard to setback from residential areas?
I did not.
All right. How about from churches or parks or other similar type of facilities? You make any recommendations with regard to setback?
I did not.
Do you believe that setback, in your opinion, setback areas separating an adult establishment from a residential use, for example, have any kind of importance on limiting the secondary impacts on this residential area?
I think that having a setback is a good idea and for any alcohol establishment.
Right. And in fact,
or any commercial business which near a residence.
and you're required to maintain setbacks from residential areas and in the different communities in which you have sexually oriented businesses or adult establishments, are you not?
No.
You're not?
No, we're not.
No other community that you operate a facility in has any regulation with regard to the location of an adult establishment?
Okay. I thought the question was, did I have to have a setback? In most cities now, there is a setback requirement. The businesses that I have purchased while they were during operation, and every one of the businesses that we operate are within a few hundred feet, some closer than this club.
But you do believe, though, that it's important to maintain some type of setback from a sensitive type of use like a church or park, library, or residential area?
Yeah, I think it's a good idea.
Okay, now you understand the setback area in Currituck County, at least, we'll say in 2000, under that ordinance, was 1,000 feet from a residential area. Do you recall that?
Repeat the question.
Do you recall that there is a setback requirement of an adult establishment from a residential area, at least in 2000, the amount of 1,000 feet?
Yes, and the Currituck County ordinance in 2000 read that there's a 1,000-foot setback.
And you understand that as of today, in the Currituck County ordinances, 1,500-foot setback from a residential area is required?
Yes.
And what is the setback distance from your establishment to a residential area at this time?
The setback distance from the building or the property
Yes,
line?
from the building.
The setback on that building is about 100 feet.
Somewhat less than 1,000 or 1,500 feet, is it not?
Sure.
And as you just testified to, you believe it's important to have a setback distance from a residential area. Is that correct?
For all commercial businesses, yes. I stated that.
And your establishment is not able to did not meet the 2000 ordinance requirements, nor does it meet the current requirements. Is that correct?
It does not meet the requirement for Currituck County as far as their setback goes.
And it's also your understanding that in 2000 it was required that an adult establishment be located in a heavy manufacturing zone?
Yes.
And is it your understanding that is still the requirement under the Currituck County ordinances?
Yes, it is.
Okay, what is the zoning district in which your establishment is currently located?
It's currently located in commercial business.
That's right. Not heavy manufacturing, is it?
That's right.
So your establishment did not in 2000, nor does it today, meet the zoning district requirement of the county's ordinances. Is that correct?
That's correct. Not in 2000 and not today.
And have you made an application, or to your knowledge, has an application been made since 2000 to rezone this property from general business to the appropriate zoning district to allow for this type of use?
Yes, my knowledge is that did happen.
And an application did happen for rezoning?
Repeat it. I'm not sure you heard your question.
Was there, to your knowledge, has there ever been a rezoning application submitted to rezone this property from where your business is located, from general business to heavy manufacturing?
During what period?
Well, we'll say since 2000.
No, there has not.
Has there ever been, to your knowledge, an application for a zoning text amendment since the year 2000 that would modify the county's ordinances in such a way that would allow for this establishment to operate under the county's ordinances in its current location?
Not to my knowledge.
So to your knowledge, you nor any prior owner has ever taken advantage of the processes provided for in the county's ordinances to rezone this property or to amend text that would allow for its location and operation at its current site. Is that correct?
There's a long, difficult history behind mermaids, and I don't specifically recall that happening.
Right. Now, to your knowledge, has the use for which this property was originally permitted ever actually operated there? A bar, nightclub, pool hall?
Has the operation operated as a bar, nightclub, pool hall?
Yeah.
Since I've known the location to be there, it's operated as a bar.
An adult establishment.
Adult establishment. Since I've known it to be there in 1994.
So your knowledge, it's never operated in the manner in which is permitted, did it?
To my knowledge, it's always been a gentleman's club since it opened.
Now, in the other communities in which you operate adult establishments, are you required to have any to apply for and receive licenses of any kind for your adult establishment?
No, we're not.
No licenses at all for the operation of adult establishment anywhere.
All the establishments that I have are the use is grandfathered in.
Okay, so
Similar to, I believe, when Mermaids opened up, there was no adult use permit required for an adult club.
do those communities in which you currently operate now require a licensure for adult establishments?
Yes,
and
for
dancers?
for new adult clubs, that would be a license that would be required.
And will you testify that you believe that's appropriate to lessen the secondary impact of such establishments on the surrounding community? Is that right?
Yes.
Now, you testify that in your opinion, bars and nightclubs are louder, noisier than a gentleman's club. Is that right?
That's right.
Yet they would be required to comply with the same noise ordinance requirements as would an adult establishment, would they not?
Yes. If the county's noise ordinance is 50 dB, then that's what it is for all businesses.
Right. So there shouldn't be then any difference or impact in noise coming from a bar, tavern, nightclub than an adult establishment, would there be?
Well, there shouldn't be, but there is.
Now, you testified that there are no other alternative locations for an adult establishment to locate in Currituck County. Is that right?
When we submitted to the county in 2015, they did not provide us with any locations.
That's much different than your testimony that there are no other alternative locations, is it not?
There were no alternative locations at that time that we submitted to the county.
No, that's not the question. The question, I mean, your testimony was that there are no alternative locations in Currituck County.
I think he testified, if I could just maybe get past the argument here, that there was a time where he looked for an alternative location, and then there's a time that he requested it from the county. Those are two separate efforts.
Yeah, we looked in 99 and we asked in 2015.
Right. And as you just testified to, you understand that adult establishments are allowed in heavy manufacturing zoning districts in Currituck County, isn't that right?
Yes.
And there are other heavy manufacturing zoning districts in Currituck County, are there not?
Yes, there are.
Yes. So there are alternate locations in which you might be able to operate an adult establishment in Currituck County, are they? Isn't that correct?
That is not correct.
That's not correct.
No. Just because it's a heavy manufacturing zone does not mean that it's within, that it's 1,500 feet away from a house, a church, a school, or a daycare.
Well, have you gone to any of the other heavy manufacturing zoning districts in Currituck County and made measurements to make such a determination?
We did in 99. We did not do it in 2015 when we asked the county. Because it's my understanding that if a site was available, that the county was supposed to provide that information to us.
Well, the county did provide you with information for you to determine whether there were other locations, did it not?
The county didn't provide any alternative locations. The county provided suggestions.
Provide you with suggestions on how to make a determination as to alternative sites. Isn't that correct?
That's what the county did. That's right.
Now, you say gentlemen's club is a much, I guess, quieter type of environment because folks are just there, kicked back, looking at the entertainment, whereas a bar or tavern is a party environment. But you have bachelor parties at your establishment, do you not?
Yes, we do.
And that's usually a good number of rowdy men, or I guess sometimes rowdy women. Is that not right?
I wouldn't say rowdy, no.
Well, they're drinking,
Yes,
carrying on,
they're in the club.
getting loud,
No, not getting loud.
having fun.
They're having fun, yes.
Just like a group in a bar or tavern does as well. Is that correct?
Just like, I wouldn't necessarily just like, if you're trying to distinguish that, just like a group would do in a bar with entertainment with a band or a dance floor, compared to guys coming in because they're having a bachelor party in a gentleman's club. That's not a good comparison.
But nevertheless, group parties occur at headlights. Isn't that correct?
Oh, yes, yeah. And don't get me wrong, they have fun, and that's what you go to most entertainment venues for. It's just louder in nightclubs and bars with entertainment, like bands and DJs and karaoke.
Now, what period of time since 1994, to your knowledge, has headlights or mermaids not operated?
To my knowledge, mermaids operated up until I took it over. And 2010, we were closed down by the county for a period of 16 months until Judge Height's order came out.
Well, that's not correct. You continued to operate, did you not?
After the order? During
the 16 months that you didn't operate, wasn't that due to the ABC Commission revoking your alcohol permit?
That's correct.
All right. The county doesn't issue alcohol permits, does it?
The county submitted to the ABC board to revoke our license at that location. Because we were under litigation, they did so. My lawyer spoke to the ABC, and they said, whenever we get our stuff settled, then to come back for the permit. So after Judge Sly's order is when we got the permit back. And the reason that the permit could be revoked was the location had beer only. So the location had beer only. And if you're going to get a mixed beverage permit, you have to fill out a new application and submit it to the city. On that application, which was part of my due diligence for buying the club, after hearing that the lawsuit was dropped and they licensed the club and the girls for the past, since 2004, part of my due diligence was that the ABC application was brought to Mr. Scanlon. It said it had to be filled out by the zoning department. It had to be checked off by the fire department. It had to be checked off by the building inspector. Further, it had to be checked off by the county manager that it was the proper person, the proper location, the proper zoning, the proper business. We submitted that application to, I personally took it to Dan Scanlon. He sent me down to Stacy Smith, recognized her because her mother worked for me for years. She said, I'll meet you at the location tomorrow. We go out to the location. She met me there with the application. I took her around the establishment, showed her all the improvements I was going to do to the club. Jason Corbel was the building inspector. Jason Corbel used to be a bouncer at Headlights in Lib City. Jason asked what kind of improvements we were going to do. I told him. He asked if we were going to bring entertainers from Virginia, and I said yes. We talked about the club. We walked around the club. The fire inspector didn't recognize him, but he was with us. Stacy, the zoning official, signed off the zoning on site at the location. Jason Corbel signed off the building was fine on location. We then drove back to the county. I followed Stacy Smith back. We went to Mr. Scanlon's office to have the final authorization on it. And he wasn't in his office right next door here. We walked down the hallway where Mr. Scanlon was standing in Ike McCree's office, and they discussed mermaids for a second. And then Mr. Scanlon signed the application and zoning and building approvals on Mr. McCree's desk.
Approvals for an alcohol permit, isn't that correct?
That was approval for an alcohol permit.
For an ABC permit, that's correct.
That's right. And in that permit,
But hold on, he was asked the question and he's giving the answer about the ABC permit being revoked and the circumstances around it. That is what you asked him about, and that is what he's explaining, that permit was issued in part by the information provided by the county, and he should be allowed to continue to answer the question.
Well, asking the next question, which was, that was an ABC permit, was it not?
yes, that was an ABC permit.
That was not a zoning permit, was it?
It was not a zoning permit.
That's right.
But he was explaining he was answering your question about the period.
Yeah, I wasn't finished answering that question, if that's what you're asking. And I think it's a very important part of this, what happened with
All right, I think
this situation.
the witnesses answered the question.
Well, I have
That's
some
your
redirect.
cross- Okay, all right. Well, let's do this. Let's let the commissioners ask questions, and then you can, information they elicit will be subject to redirect and recross. All right. Excuse me. Bad habit. I hang around with bad people a lot. Okay. Members of the Board of Adjustments, it'd be appropriate for you to ask questions now, if you have any of this witness.
I'm listening right now.
Okay.
Just a couple follow-up things. You said you serve food there, is that right?
Yes, we do.
There's an inspection process that goes with that, and what has that process been like in the ratings there?
The health department comes out periodically to check out the kitchen. They go through the refrigerators and all the food stuff. We've, as far as I know, gotten a grade A rating since we've been there.
And I think you said in the membership application, do you do a background check on all your members?
We don't do it on everybody.
Okay. And we recognize that it's in a general business, and I think my understanding is if it were a bar and tavern only, that would be acceptable use in this zone.
I disagree. I think that if there was a nightclub use at that location, that the homeowners association would have been here at almost every meeting that you guys had, complaining about the noise and the disruption.
We'll object to
That wasn't the question. Would a bar be a permitted use?
Under the Uniform Development Ordinance,
Nightclub.
Yes.
The niteclub would be a permitted use. That would be a permitted use.
it would require a conditional use permit, I believe. It's at that location. This was given a conditional use permit.
Wasn't it given a conditional use permit for a nightclub?
Yeah, initially, yes.
It was initially given a conditional use permit for a nightclub.
But it's your opinion with your testimony tonight that your establishment actually is a better neighbor than a nightclub.
Yes, 100%.
I have nothing further.
Shay, anything?
Was not that permit that you're speaking of revoked in some way at some point? I think
You're talking about the conditional use permit. It was revoked, I think approximately 1994 or 5. It was initially granted, but then when Topless Entertainment came.
We're going to object to the testimony of the attorney.
Yeah, well, I mean, it's in the record. It's in Judge Height's order.
But yeah, I saw it here. I understand that. That's why I asked the question, because it's contrary to the testimony we just got.
I think the question was whether or not you would be required to obtain a conditional use, or whether or not a permit would be required for a bar or nightclub at this location.
My question.
Under the current UDO, that's I think
We
the question.
seem to be driving this in a direction I don't think it was intended. But I'm satisfied that, so we're still without a special use permit. That's my point.
Yes, and yeah, I haven't owned a bar its entire time. I
understand.
Came on in 2010.
Okay.
Thank you.
All right. At this time, it would be.
May I ask a question?
Sure. I'm sorry. I thought there were no others.
Thank you. As far as the alcohol permit, the things that had to be signed off in order to obtain the alcohol permit, if I read everything correctly, had to do with whether it was zoned properly and stuff. Is that correct?
That's correct.
So if the county had felt you're not zoned properly, you would have never gotten the alcohol permit.
We wouldn't be standing here today if that application, if I had walked into the county and the county manager would have said, "Oh no, that's in the wrong zone," and the zoning inspector said, "No, this is not the right zone for this. We've got an ongoing litigation. We've got this. There's not a conditional use permit." The business had sexually oriented business license hanging on the wall, as well as the entertainer licenses. So the ABC application has on it proper zoning, proper zoning and whatnot on there for the fire and all that. But the important part of that application is it's signed off by the county manager. In addition to the zoning manager, is that it says proper location, proper zoning, proper person, proper business. The county manager, after the zoning inspector checked off on it, had to additionally check off on that stuff. So once we were handed that, that was our paper, or our, in our mind, our permit or approval to go forward. The business already had a sexually oriented the business already had a adult business license, a sexually oriented business license hanging on the wall. So the corporation didn't change. But after receiving that from the county, we went further, opened the business. And of course, I don't know if you guys are familiar with ABC permits, but once you apply for a new permit, it goes under a 90-day temporary. When it's under a 90-day temporary, at that point, it can be revoked for any reason given. The previous permit was a permanent permit, and you can't, the county couldn't just send a letter up and have it revoked. The ABC just couldn't come out and have it revoked. Board of Commissioners couldn't have it revoked. But when you get a new license, it's it's of a lot of people's knowledge that it can be revoked within 90 days, and that's what happened. A letter was sent to the ABC that the business was not in the proper zone, and they recommended to have the ABC permit revoked. So after the ABC permit application was given and the permit was got, the letter was sent up to revoke the permit.
What letter?
Letter from the county, from Ike McCree. So we could have saved ourselves a lot of time and trouble if I would have walked into the county and they simply would have said, this is not the right place for this business. That's what I would rather, that's what I wanted. We relied upon that document to move forward, in addition with the permits and licenses hanging on the wall in that business.
Okay. Yes, sir.
I just have a couple of redirect questions based on Mr. McCree's cross-examination. And you were asked about your thoughts about setbacks, but you didn't have an opinion that a setback had to be 1,000 feet from a residence.
I did not.
And currently, you're at least 100 feet or more from any resident. Is that correct?
Yes, approximately.
And in fact, the resident behind you was constructed after the operation of Mermaids had started.
Yes, it was.
Well after. It's around 2006 when the operation began in 1994.
It's my understanding from my census that everybody on almost everybody on Acorn Lane built there or moved there after during the operation of Mermaids since '96.
And when you were asked about the ABC board having revoked your ABC license, what you're stating, and I'm just trying to make sure everyone's clear, you're stating it was taken while you had a temporary status for the new mixed
beverage license,
mixed
right.
beverage license.
We went from beer to mixed beverage, and to do that, you have to have a new permit.
And that was based on a letter from Mr. McCree to the ABC board alone, and you were not given any procedures or proceedings in which to contest that. It was just an automatic revocation.
Right, because it was a temporary permit. That's right.
Okay. You also were asked about alternate locations, but you did try to find alternate locations in 1999. And what was the, and I think you've already testified that you were unable to, but you were also directly asking the county to provide you with alternate locations, and that was not done.
That's right. In 1999, we took a map and drew a circle around every possible spot we could find, and there were none available. In 2015, it was my understanding that the county was to provide, if asked, location, where location would be to locate a business that it was supposed to be provided.
And with regards to the alternate location, even if you were to locate at a heavy industrial or heavy manufacturing location within the county has testified you would still need to come for a discretionary permit. That could still be denied by the county.
Yes.
And going back to the setback issue, and I think this may go to the question of the commissioner, the county, excuse me, of the Board of Adjustment member, thank you. I don't want to elevate anyone to a place they may not want to be.
We're appointed.
And so the issue of the setback, the county has stated in its presentation, very presentation today, that there would be no secondary effect, none, from a bar or tavern. Isn't that correct?
That's what they stated.
and there has not been any evidence produced showing any distinguishing factor of a gentleman's club that would make it a more problematic establishment.
The county has not brought any information forward in that regard, no.
I don't have any more questions.
Any other witness?
I do not have any other witnesses, but I do have some designations I would like to parry over with you.
Yes, please.
Designations.
Okay. Excuse me, we do have one other question.
You spoke of a permit that you had from the county. Don't recall if it was our last meeting or the one before, but there was a permit presented by your council, signed by the sheriff for an adult entertainment. I don't have it here to properly name
Sexually
it.
oriented
Is this the
business.
permit you're talking about?
Yeah, there's a permit for the business called the sexually oriented business permit, and it's been
I
issued.
think you need to
to
be careful and make sure you understand his question.
Okay,
You're
right.
saying the permit you're talking about.
The permit he was talking about, he had from the county to operate his business, is the same permit signed by the sheriff. It's you presented it. Is this a permit we're talking about here?
We also talked about the ABC permit.
I
or
understand
license.
that, but these are
Okay.
two different.
They're
That's
two
two
different-
different things.
right,
Okay,
that's right.
Okay, so you had an ABC permit to sell beer. You wanted to revise that to sell mixed beverages. Two different permits. So now we're into three permits. Am I correct?
Right. Well, the mixed beverage permit takes place at the beer
Well,
permit.
I understand that,
Okay.
but the point, what I'm trying to establish here is this permit by the sheriff, the planning department, nor the legal department, nor this board, nor the Board of Commissioners were applied to for that permit, nor did they give you that permit, and that's correct. The
That's
sheriff
correct.
gave you that
The
permit.
sheriff issues
Okay.
that permit.
We visited that before and spoke of where the authority came from for that, and I think we established Counselor Judge Height, Sheriff Johnson assumed that Judge Height had ordered her to give that permit because that permit was not authorized by anyone but her. Is that correct?
I think you're
That-
mistaken on
I
that.
don't think so on that. The permit, well, we
This
can
was a
judge from-
yearly issued permit.
I understand that, but
Sheriff-
it sounded
sheriff
like you
permit
were
is-
trying to establish that despite it not being heavy industry, that permit was still valid, and that was the permit we're talking about. And
There are multiple
I'm not
permits
seeing
involved.
it that way.
Yeah. And it goes back to 2004 that particular permit was issued at this facility.
And was done annually.
Every year.
I understand that.
Mr. McCree, did you want to
I was
address?
just going to remind the board, we went through this exercise the first night of this hearing back in January where we went through the code of ordinances under which the sheriff was required to issue a permit for this establishment separate and apart from what the UDO might require.
Correct.
But that's not ours to deal with.
No.
That's what I was trying to establish.
Judge Hyatt's findings said that the Board of Commissioners authorized on July 7th of 2003 that would be handled by the sheriff of Currituck County.
But it's still separate from what we're doing here today.
Correct.
Right.
And that's what I wanted to establish.
Okay.
Thank you.
Anything else? Any other questions for the witness? Mr. McCree, Mr. Morris, any other questions that we should ask of the witness?
No, sir. I mean, that's in your discretion what you choose to ask or not. And I think we're drawing to the close of the evidentiary portion.
We are.
Is that correct? All right. I would like to put something on the record. Oh, I'm sorry.
I do want to, in light of the question with regard to this ABC permit, ask a couple of questions of the witness.
All right.
We've closed this question, and I'd object to any additional questions.
It's within your discretion to open the evidence, even if it's contrary to normal procedure. So you can allow Mr. McCree to or not.
Mr. McCree, please go.
Thank you. Now, Mr. Brown, you're familiar with this ABC permit that you were testifying to a little while ago, are you not?
Yes.
And you recall that that there's a line that says zoning classification on the permit?
Yes.
And next to the zoning classification, the permit read general business, did it not?
Can I see it?
Let me see it too.
It says zoning class, general business. Stacy Smith. This is part of the record, 336.
Again,
Yep.
what was the zoning classification that was written on the permit?
Okay. Stacy Smith filled this out, and
Yes.
Stacy Smith put general business,
That's correct.
nightclub and bar.
Right, and yeah, the use, permitted uses in this zone read what?
Permitted uses in this zone, it doesn't read on here.
It does, what does it say right there on the permit? What does that say?
Well, Stacy Smith wrote down that the permitted use in this zone is nightclub and bar, but the applicant for this is Mermaids.
Right, but the use.
How much clearer can that
The
be?
use written on the permit by Ms. Smith was nightclub and bars, isn't that correct?
That's what she put on there, yes.
I don't have any further
And
questions.
I do object again to that line of questioning. Y'all rejected taking and reading the extensive testimony provided at the Board of Adjustments hearing previously on this matter in 2010, where that was discussed at length. Those items were discussed at length. Mr. McCree objected to that coming in, and now he's pulling an item out of it and asserting it as somehow relevant at this point, but he's doing so not based on any redirect. He's doing it out of context and using it after having objected from the very proceeding being considered by this board, and so I think that's inappropriate.
My counsel is that objection should be overruled. It's in. The evidence.
That permit is in
Mr.
the...
Plumlee's objection should be overruled, is my counsel. The evidence has already been received.
And it was he that brought it up, so it had to be addressed.
No, it was Mr. McCree that brought it up, and
What?
in his line of questioning, he asked about the loss of the ABC license.
All right, just a minute. The document has been discussed by the witness as a rule of law and evidence. The document must speak for itself. Mr. McCree is pointing out certain things that appear on the document. The document is in evidence, I believe.
And I've
otherwise.
objected to it in advance, and I'm objecting to it again.
Okay. It may well be that the evidentiary quality of that document is remote, but my counsel to you is to overrule Mr. Plumlee's objection. It just goes to what the witness testified to last.
Okay, we overrule the
Overrule it.
objection.
All right.
All right.
I do have one other item of evidence, if I could go ahead.
Yes.
These are designations of the record of proceedings. The record of proceedings was created in May of 2011 of the previous Board of Adjustment proceeding in 2010. And what I've done is I've selected, we rejected the full record. I've selected testimony from that record. These are all statements by county officials, all statements saying in essence they didn't know of the operation going on for years at Mermaids.
Are these summary statements taken out of the transcript that was previously received in evidence?
It was not the one that was received by the board, it was rejected by the board. And what I'm asking is to allow these few designations, very short testimony, to be considered by the board.
We object again on relevancy and the same reason for which the board did not.
Yeah, the
admit
Relevance
any
is
of
a
that.
moving feast, right? Okay, so is it relevant to now consider a portion of that record and allow it when you rejected it for the county? Is it relevant? I believe it is. When the county makes statements that they don't even know there's an operation going on over there and they want to say there are secondary effects coming from it, it's quite relevant. I have those statements in a very concise format for your consideration.
All right.
If they speak to secondary effects, should we not be?
Well, let me see what you've got, but my concern is these are extracts taken out of a document that you previously ruled was not admissible. Is that correct, Brian?
We know that
Well,
it's word for word
first of
pulled
all,
out.
when I was attempting
We know it's
to
word for word pulled out.
object
We will
to
get.
place general objections on the county's large exhibit, which recited all kinds of materials, I was told we're going to go through it line by line. But when I hand up this big exhibit, instead of going it section by section, Mr. Morrison flipped through it in less than 15 minutes, and y'all came back and said it's all objected to. What I've done now is I've said, here are sections of it, testimony from county officials, admissible as against a party opponent in this proceeding, and I'd ask that they be considered by you all for the purpose of determining whether the county has said to this very board in a prior proceeding that they don't even know of this operation ongoing over there. And that's relevant as to whether or not there are secondary effects from this operation.
All right, I understand your argument. I'm going to need, even though this is condensed, it still looks like it's about 10 or 12 pages. I'm going to need to look at it first.
It won't take you long, but yes.
Yeah, I would
Okay,
need
then
to
we'll take a 10-minute recess.
A 10-minute recess would be sufficient. Yeah, I can do it in
Okay.
10 minutes.
We'll take a 10-minute recess.
How much longer are we gonna meet tonight?
We didn't establish it.
I have an hour drive home. What, y'all think?
Yeah, it is 8:30. Wait a minute, don't anybody go away.
I mean, how
We
much
have
longer is
extensive-
tonight gonna be? 2 hours
Miss-
longer? Or if it is,
Yeah, it could well be that. You have to do your deliberations in public. There's quite a bit of evidence you would have to consider. Yeah,
don't we?
I think you're going. Yeah, you have to do your deliberations in public.
I mean, we still have to have time to meet.
Yeah, Mr. Chairman, members of the board, what would happen next after we deal with this evidentiary issue and a recess is you would then hear closing arguments, which I would hope would not be lengthy, but anyway, you have to hear from both sides. You would then need to review the evidence to your satisfaction, which could be you're satisfied you've reviewed it right this second. We then have to take Judge Tillett's order and go through it line by line. There's quite a bit there. Then you have to vote on each one of those issues Judge Tillett laid out for you. So I could easily see an hour and a half, because it's going to be 8:45 when we come back. And I know we got one board member that lives in a galaxy far, far away, to make the Star Wars analogy.
Well, then let me see if I can bring this to a close real quick. Let us come back from recess right now, and then I'll ask for a motion from the board
For other recess.
to recess until.
Can we address this when we come back before we recess?
Would this have
That's what
relevance on our decision?
That's what I'm trying to make a determination.
Yeah, I'd rather wait. If we're gonna be able to get this evidence, I'd like to be able to take it with me so I can look
All right.
at it.
And
So
if
lem-
you do that, then one way or the other, I can close my side of things for
Yeah, all
evidentiary
right.
purposes.
And so that when we come back, all we're going to hear is final arguments, right?
Right.
Okay, all right. Let me look at this, Mr. Chairman.
All right, so we are in recess right now.
I can do this in 10 minutes, yes.
Okay,
recess.
we're in
Okay.
recess.
I'm good. I just don't want to be driving home 10, 11 o'clock at night. Yeah, I wish. How many school teachers have limos?
I know some, but not here local.
Yeah, I almost hit a deer. I almost hit a deer the last time, so it's like, and I have hit one before.
That's a fun thing, isn't it?
sale.
We are coming back,
Okay.
and then we may go home.
No, I mean, in another 2 weeks,
Oh,
we'll come
yes,
back.
we are coming back in 2 weeks.
It'll be a fourth session, okay. Well, whenever but it seems to be 2 weeks, so it's consistent, but
We used to have a budget to pay. You guys need to get the whole fee to official budget this year.
Doing what?
We budget to pay you guys for 12 meetings. We're actually we're gonna use the whole budget this year. We're gonna use it in like 6 weeks.
Yeah, but their lawyer's fee comes out of my budget.
So he did budget worse than,
Yeah, I think so. Yeah, I know,
if you have budget to pay off for 12 meetings, that'll be like 3 times. So we'd have,
I asked her, I said, am I only getting that one pay for the whole thing? Yeah, thank goodness gas price went down. I just spent $400 on my car, so I'm still in the hole.
we may get there. I don't know. You're on our way.
And I don't know what the difference is, but I'm paranoid to drive at 10 o'clock at night and not at 8 o'clock at night, but
Later, you know, I'm understand. It's fun to get home at 11 or 12 o'clock at night.
that's right. Yeah,
Car
because they
breaks-
are
car
out,
breaks down.
and that's what worries
You'll
me.
be on the phone, so I get it.
Right, this is a continuation of the first meeting.
We would have been done a couple meetings ago. I was in charge of it.
I mean, half the stuff that they talk about, we've already heard, and it's like,
That'd be good.
all that stuff about that survey, that other man testified.
And then we didn't even get to see it.
And, but then they were contradicting the guy that testified. In Las Vegas, there were 14 people, and he said there were 30 some, so. Had a long day. Yeah, I know, but
I'm gonna do that next time. I'm gonna bring a bag. I'm gonna walk in with a brown bag.
pure,
Say,
yeah, I know.
Camera is not playing.
Probably got the reach.
Oh my goodness.
Yeah, I mean, when they would show us a picture, I thought I was gonna see a picture of how close it was, but I mean, that house could be in Corolla for all I
Market
know.
sweater.
You know,
Nice job.
you know what I
You
mean?
picked it out?
It tells me nothing where that
I
house
did.
is located. That
Wow.
could be his house. He took a picture of his house for all I
I
know.
don't pick out anything good.
My favorite one, it's all black.
And you
with a
tag on
NC
that
State
car.
logo on it. I
Oh
love
boy.
that. Yeah.
I wasn't sure I was gonna make it.
I mean,
One
and
of my trucks.
basically, that's the same thing.
I had three, I thought one tire was
That
bad.
ain't
Started
telling you
looking at it, I had
anything.
three tires that really
things
shouldn't
fall
be like
apart
that.
on the beach.
Yeah, I think,
It's not like,
you know, mine's
But-
supposed to be,
Yeah, I said
couldn't be
like
bad.
How do I
I'm
know
gonna
that's-
send that gas out there.
Right.
No, I'm gonna go get some tires.
Right.
I looked at my watch and I said,
Well, you don't have to worry about school.
oh
I
yeah.
really felt like the restaurant comparison was very
What time
irrelevant.
I got in here, I
I
was
will
only
not
about
support that part.
5:28 or something.
It's funny, cause,
When it's apples and oranges.
I knew I had this meeting And I knew what time it was. And I had, you know, I had to do some business. I had to go to Gates County. And I was sitting up in Starbucks in Virginia. And I was reading through the material.
Oh,
I knew I had a meeting
but
tonight.
there's the whole.
And I knew what time it was, but I didn't think of it. Because I'm sitting there going, Board of Adjustment, 7 o'clock. You know,
I'm not saying
I never
his
put
is
the
better,
two together.
but
Danny called me and she said,
they're different.
but they're different. I was like, what?
And AJ's
4:30.
definitely
I'm like,
different.
I'm so glad
I would take my child on AJ's. I
Because
would
it
take
just
my
clicked. I
child.
went into the office and I said, Debbie, I'm gone. This is like 5:25. I mean, almost 5. I didn't know it, so I'm going.
I don't know anything about that
I
one.
said, no, baby.
I don't know anything about that one, so I couldn't visualize anything there.
She said, but you haven't eaten. I said, I'll live. It won't be fun, but I'll live. John, I pushed the wrong buttons. But I think
It looks good.
Where is that at? Where's it at? Where's it located?
As soon as you turn down the shortcut, right down the right.
Recycling center, just pass it on.
You can clean up your stuff.
Little Quonset.
Yeah.
Shortcut is that Shawboro?
Frog Island.
Could be.
Oh, yeah, okay, Barcode. Okay, I know what you're talking about, okay. It used to be a hole in the wall, wasn't
Yeah,
it?
change the names better.
Yeah, okay, I know exactly. I used to spend time there when I was a
Mr.
teenager.
Morrison, just let us know when you're ready.
I'm ready.
Oh, you are ready? Is everybody ready? Okay, we are back from recess.
Mr. Chairman, if I may, I have reviewed for the record, Madam Clerk, what is exhibit will this be? Petitioner's exhibit what? So I can identify it.
I am assuming number 7.
Number 7? Okay. It will be marked for that purpose. Members of the board, what has been offered is portions of a transcript from a 2011 Superior Court proceedings, London Incorporated, Inc., Mermaids, Inc., versus the Currituck County Board of Adjustment in Currituck County. These are excerpts from an exhibit previously offered by the applicant, which was denied, and I canceled you. That was another proceeding on other issues, and therefore it was not relevant to what we were doing, to our decision. What is before you now is about 10 pages, which I have been able to review in the recess. And as I understand it, it is being offered solely for the proposition of whether adverse impacts existed or not.
Right.
Okay. These are statements by various Currituck County officials that they were not aware of mermaids. And I assume the inference you would be asked to draw from that is if they were not aware of it, then it wasn't making any problems, and therefore there would be no adverse impacts going on. You're not required to believe that, but that is a conclusion you could draw. Whether you do or not is up to you. So on the sole issue of whether there were adverse secondary impacts, it would be my opinion this is admissible. Now, what the court did or did not do in this entire proceedings is still inadmissible, because that was another case for another matter. But there is testimony under oath and subject to cross-examination, which is relevant, not saying you have to believe it, but is relevant on the issue of secondary impacts, which we were ordered to address and make findings.
If I may be heard.
Yes, please.
The key point is it is only a snippet of the testimony from each of these individuals. If you look at the bottom of the pages, it skips many tens of pages between the statements or testimony made by certain county officials. It's taken
I found that to be
just a minute.
Go ahead. Sorry. Go ahead.
It's taken solely out of context. It is not the full context of the testimony. It might lead you down one path when the full context of the testimony is an entirely different subject matter or has an entirely different meaning. And so on that basis, we'd say it's not relevant. It is being admitted solely for confusion. It's taken out of context and not relevant to these entire proceedings. So we object on that basis.
All right, Mr. McCree's points are well taken, as there may be additional information that would lessen the credibility of these statements. And I think he would be entitled to submit rebuttal evidence at the next hearing to flesh this out if he wants to address that. But whether these statements were made and what weight you choose to give them, including none, it would be relevant, competent evidence. And Mr. McCree will have the opportunity, I assume. Ike, have you got the whole transcript of this?
Yes.
Okay.
Of course, I haven't had the opportunity tonight.
Sure, yeah. It couldn't happen tonight, but when we show up the next time, you could have a similar limited document, I would assume.
Yes.
And then you can consider both. So that is my counsel.
May I address Mr. McCree's objection?
No, I think we understand what the issue is.
Well, I do have a right. He's gone down a different path than what you brought up, and I do want to address this issue of there being other pages that he brought out.
Well, it would be up to him to submit those pages if he wants, and the door is open, and we're perhaps being a little more formal here than the law requires us to be. I'm bending over backwards, and boy is the board to give everybody a fair hearing on this, but we're required to render due process, not a perfect trial measured by the standards of Superior Court. So that would be my counsel, and nobody is lying, cheating, or stealing in here. Everybody's being honorable, and both sides are very ably represented. So the hour grows late, Mr. Chairman.
Mr. Chair, I would recommend that we receive this into evidence with the county the option to submit rebuttal, and hopefully we don't have to entertain the whole package at some point down the road.
Mr. Chairman, my concern is this going to take us a path that we need to go down or create confusion that we don't need? I'm not trying to make a statement. I'm just this is where my thoughts are on this. Is this a path we really need to go down?
I think until you read it, you won't know that.
Yeah, I think that's been said in Washington.
Yeah.
If we accept this part and then we accept his part, won't we just be accepting what we've already denied?
No, ma'am, because what was denied to you before was the whole transcript, which it looked like to me was several hundred pages, which would have had rulings and dealt with issues that are not before the board. This is being offered for the limited purpose of secondary impacts. And the inference, which you may or may not draw, that if the county didn't know anything about it, then it couldn't be causing secondary impacts. Ike has raised a very valid point that you're only reading, to use his phrase, snippets, and he can make a similar condensed version, which would arguably bring these statements into clarity, that they don't purport to show what Mr. Plumlee says they do. But it is your decision, not mine, as to what evidence to entertain. But that's as clearly as I can state the argument.
And in the end, we weight each one as we see. Okay. Then at this time, I will overrule the objection, and we will allow it into evidence for the sole purpose as stated.
And I would, since you're being left with the impressions of Mr. McCree, would like to address the statements. And I believe I have the ability to do that, in that he objected to the entirety of the transcript. What he is going to have to present to you is rebuttal that shows that somewhere in this transcript, these officials did not mean what they stated here, that they didn't know of the operation of mermaids. A very simple proposition, not a complex one. Not a complex one at all. That's all I want to say. I'll hang here.
That'll be up to Mr. McCree to do. So.
All right.
All right, so we're going to receive this, and then
Recess, I guess.
we'll recess because we will have to have time to read and process this.
Well, and I think the other reason for the record, your recess should reflect that
The time.
this time, and we have a witness that lives in Knott's Island. I mean,
We have a
not a
board member
witness,
that lives
but
in
we have
Knott's
a board member.
And if I can save it for the next time, I would like to just enter into evidence certain exhibits that I've handed up, and if it's to save time, I can do this when we
All right,
return.
let's do that when we return. The hour does grow late.
All right.
So, Mr. Chair, you must first entertain a recess. That's within your power to do alone, but you must state the time and place where we will resume.
Or we'll resume. And Mr. McCree, Mr. Plumley, and Mr. Morrison, a lot of that will be dictated by your schedules.
I have no life, Mr. Chairman, and I'm usually available at 5:30 on Thursdays because there's nothing exciting taking place at my house.
At 4:30 if we bring a glass.
Yeah. Oh, and we can stay all night. And I understand if we just turn this into a bar, it won't be near the problem that Mermaids is. So we can,
I'll bring the bourbon.
Scotch.
Right, okay.
Well, I am available.
2 weeks from tonight, is that?
I have a problem with 2 weeks from
Okay.
tonight, and I'm going to be gone 2 weeks from tonight. Let me clarify, is that the 25th of February?
25th, yeah.
I'm available.
Mr. McCree? Ms. Morrison?
Yes.
And board members, would everybody be available 2 weeks from tonight?
Yes, sir.
I'm good.
We're good? Okay.
My calendar, I have a life, but
Then
At
at this,
5:30, is that also?
yes, sir.
They'll give you luck.
Okay, at this time, we will recess the meeting as we have one board member that has a long drive back to Knott's Island, and we have some material to review. We will come back February the 25th at 5:30.
Being a good copy of this.